Hello, beautiful people. How are we doing? Sorry, I'm a little bit late. I just published a new video. I think I published it. Let me just check if it's gone live. I don't think it's live yet. Let me just see. I've set it as premiere for you guys to watch later on. Let me just check it. I hope you can all hear me okay. I hope you can all hear and that we are doing all right here. Um, Boom, 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 boom. I will be with you in 1 second once I figure out what the freaking hell I've done. Do, 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 do. Live, no. Video, yes. Members only they are, so that's why. Don't think it's gone live yet. Let me go in the background then, studio. YouTube studio. Content. Oh, it's premiering. Is it premiering now? Don't tell me it's premiering now. I don't want to premiere now. Oh, maybe I do. I don't have a clue. Let me just see if it's premiering now. I've got premiere out there. Hello, Mary. Mary, quite contrary. How are you? You got a new. You were given a gifted a membership, Mary. So somebody I don't remember who it was very kindly gifted a membership. Hi, Christine again. Fortunato. How are you? Hit the like when you weigh in. Thierry's here. Thierry's playing catch up. Hello, Thierry. How are you? Welcome back. Lovely to see you. Welcome. Here we go. Lazy Bones is here. Sarah P is here. Welcome, everyone. And thanks for joining. Please hit the like, subscribe, and hit the notification bell on the way in, please. Yes. Um, Obviously, I think most of you here are members, but if you're not, consider becoming a member. 2 levels, Taco, Blue Wench, both the same things, but trying to make it affordable for everybody. You get access to members only, where you get to see me set up audio and all that crap, and access to our Discord. Check the official Alternate Corner merch store. Yeah, people asked for it, so I've done it. And some people have bought, and they enjoy it. So it's up to you guys if you want it. Please support the channel. Consider donation, please. Stream elements, yes. Rather than doing staff chats, super chats where I only get like 35% of it. If you do this and click that link, which is in the description box, that means I get, I think, 89% of it or something like that. So, as Sarah says, never required, but always appreciated. Hello, Mary Christine Thierry. Hi, guys. Hey, Katie. Oh, Jesus, there's a lot of people here. Sarah P. Hey, Sarah. Hey, Kay. I'll stick around as long as I can. No worries, Thierry. It's only the conference thing today. So it's not like it's only the jury instructions. It might only be an hour. I don't know. Hello, my darling. Hello, Emma. Blue ones. I didn't get to finish yesterday. I was still on first witness. Yeah, I mean, I say this is just jury instructions. So, I mean, you can skip this. It's all good. So, unless it might only be an hour max, maybe. So then we'll finish. Hey, Thierry. Hey, Thierry, Emma. Hello again, Emma. Okay, cool. Thierry, did you see the ME and toxicology brought in by defence? So any impressions? So no, she hasn't yet, I don't believe. No, there we are. Not yet, Katie. Gotcha. Still first was very informative. FBI lady. Hi, Delan. Hi, Katie. People don't understand drug interactions, how they absorbed half-life, etc. How some meds even affect how others absorb. No, Katie. Coffin man. T, I think you find on ME and toxicology interesting, yes. Coffee Man's toxicologist, yes. FB was the day before, right? Yes. Someone sounds really good. Do I? I don't know. I have a clue. I can't hear myself. Hang on. Hey, I just want to check, Jonathan. And also, shout out to Jonathan. He did set me up offline just now. I don't need these then. Just checking out, Jonathan. I got 2 cables here. that I don't need then? Just checking, just in case. There's 2 there that I haven't used. Emmy was after her. Was she? Was he? Don't remember actually. I know they don't agree, but prior, Lynn wrote all that shit. They most people do agree. Hey, Jonathan, skip all the rest of the defense with it. I think not. No, you shouldn't need these. Fine. Happy days. Right, can I hear myself then? Is that what we're talking about? Can I hear myself? Hello, hello. I can't hear myself. Hello, hello. Hello, hello. No. Okay, so I can't hear myself. I could with Jonathan, but now I can't. I could earlier on when Jonathan set it all up, but now I can't hear myself. But it's all good. It's all good. It's all good. It's all gravy. Maybe I can once the stream starts. I have no idea. I don't know. But Jonathan, thank you, my man. You are the man. I just need to get everything ready. Also, you might see my mic. I'm not sure if you can see it. My mic is all the way up here because my boom broke. My boom broke, Jonathan, so I can't pull it down. So if I pull it down like this, pull it down like I usually do, and put it here, once I let the Jesus Christ. Ah, fucking. I thought it was flying out. I thought the mic was gone. It's still there, but I can't. So it's up there. I can't pull it down. Doesn't it have a lock knob? What's a lock knob? Oh! So this is here, right? You can see this. This is here. Like, obviously, this is the knobs here are for this. But then, oh, you can't see the other side. Here, there's nothing here. Does your knob lock? Hang on, let me get at this. I got my room's a mess because of all this. So there's nothing there. Do you know what I mean? It goes like that, and then that's the bottom bit of it. Maybe put it backwards. But I don't. If you, yeah, but I don't think it fits, Jonathan. I don't think it fits properly. Hang on, let's have a look then. I don't fucking know. I can't even fucking screw. I chuck something. Right, I got this, 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 this. I fucking don't know how to do it. Am I even on now? Hello? Hello? I have. I don't know how to fucking screw it in. Look! That, I'm trying to screw it in. It won't screw. But it screws this in, so it doesn't fit. It doesn't fit. It doesn't fit. That's what she said. So it doesn't fit in this road thing. It doesn't fit in it. I don't know what that is. I have no idea. Probably should have left it alone. Down. But I don't get why this thing won't work. Why won't this arm work though? I, the arm, watch it. The arm. This is the arm, right? I let it go. Fucking hell! It's fucking flying. There's no way for me to screw. No way to screw here. This is the only place I can screw. Is here. That's it. Look at it. It's fucking going. Oh no, I can't do that to Paddington. Look in the elbow of the stand. Hi, Kim, for tightening it. Elbow of the stand. No, no, it doesn't. But it maybe it used to. I don't know. Maybe it used to. Hiya, Sherry. He needs a screwdriver. Fucking need one screwdriver. Let me tell you. For where? Fuck that screwdriver. Where? But I don't need that. That's tight. That's tight. Right, let's try again. No, fucking it goes up and down, man. Right, let me just. Right, that's tight. See? Catch it. Watch it. Could there be a screw at the very bottom? Well, the only screw is here, but it's tight. I can't, Josie. If I could, I would. If I could tighten the arm, I would. Honestly, I would. No bullshit, I would. I just can't. I don't know. Stiffen the. Oh, fucking hell. Right, I can't do it. I'm just gonna leave it. Right. This piece goes in there, right? So I got this and this. They go fucking fly in. So it goes in the hole like that, and then boom. It's done loosen that screw too much. So what? You're saying these screws? These screws? Okay, I'll get a screwdriver. Okay, bear with me. I'm getting a screwdriver. Well, I don't think they need to be tightened. Right, I don't think this is going to work. No. Because, no. Oh, maybe this one. Nope. Right, those two are tight. The middle and bottom one are tight. You can't get tight there. The elbow joint's tight. Right, so this one, I think this is broken. Because every time I spin it, I can spin it. Do you know what I mean? So I think this is the issue. This is the issue. Oops. This. Because it keeps turning around. Yeah, this is the issue. It keeps turning. The wheels keep turning. Too much before they finish. Yeah, so it's this one. I can't do anything about it. Whoa. No. No. It's better. It's better. It just means it's loose. Do you know what I mean? So every time I take it, like I can't get hold of it. So it's done. That one's done. But the others are fine. I just have to do without this. There we are. So I can't do anything about it. So my mic is up there. It's that bit it is, because the others are fine, the tension's fine. Oh, look at that. Oh, motherfucker. I think I've done it. I think I've done it. It's right here now. I think I've done it. No duct tape. It's done. I fixed it. It's there. It's obviously going to go flying at some point, but it'll do for now. How's the audio? How's the audio now? Is it better? Oh, now I've got tangles everywhere. I think that'll do until it busts up. The sound is awesome. Happy days, Sherry. Is it echo? Is it echo on it? Because that's what I'm scared about. Is it echo? Jonathan, I can't hear anything. Yeah, can't hear anything. Can't hear anything. No, can't hear anything. No, can't hear anything. So I'm not sure if I'm supposed to, but I can't. But it's all good. Oh, right. Let's see. Let's have a look here. I know it doesn't play through it though. It's fine. Oh, that will, but I can't. Earlier on, you did it so I could hear myself. Now I can't hear myself. But this is it's fine. Don't worry about it. This is a court now, so hang on. Let's present this. I'll be able to hear this though, so it's fine. That's all we need. How's my volumes though, guys? How's my volume? This is the sound properties for you, Mike. Let's just make sure this works, and then right, say something. Hang on, Jonathan. Right, I invited you. You're offline, apparently. Well, I've shared the thing with you anyway. Zero noise. Okay, fine. See, I'm a genius. I think I've done well. No, to be fair, Jonathan's helped me in the background as well. I've invited you. Yeah, you got it. It's under your control.
Will you send
Yeah, got that.
me? Well, actually, I have the printed copy, so I'm okay.
Okay. Okay. Okay. I can't hear myself though, but no, I can't hear myself now. Let me try it. No, but it's fine though. It's fine.
Oh, I forgot to put this back in Judge Burton's office.
In where? In the Judge's office?
No, there was some here. It's a statute book, a big old statute book.
Hello, hello. Hello, hello. No, hello, no. I'm not going to touch it. It's all good, Jonathan. All good, John. All good. As long as my level is fine with court, that's fine. Sing, baby, sing for us. Ah, oh, happy day. Oh, happy day when Jesus was. When Jesus was. Oh, happy day. Do, 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 do. I can hear court, yeah. I can hear court. Just Jonathan had it so I could hear myself as well. So I could see what levels I was at against court. But I can't hear that. So I don't know if I'm shouting now. I don't know if I'm too quiet. I don't know if it's too. I don't know. I'm trusting you guys to say that I'm okay. Thank you, Kimmy. Thank you, Kim.
If you're looking for Judge Dama, he's up a floor. Yep, he's in 1016. This is 13. Yep, one floor. Not that you couldn't color that, but I just figured I know where she's going.
It's all good, John. It's all good. This is how I've always had it anyway. I just got rubbish everywhere. Boxes, tissues, everything on the floor here.
They're what? Perfect.
Yeah, no, I'm not. Hey, cheeky fucker. I'm quite good with computers, but I'm not at that level. Do you know what I mean? I'm just like, it was soft. No, I can't soft reboot. I don't know what soft reboot is. Court could go up. I could put court up. There you go, Kim. How's that, everybody? Well, I've just put court up, so it should be fine. Is that better? Well, I mean, we don't know yet because obviously they're not speaking yet. Yeah, let's wait for them to start. Language, oh, quite compared. Yeah, let's wait till it starts. I've turned it up, Junior. I have turned it up. I've turned it up.
All right. All right, we will go on the record then. Good morning, everyone. The court is calling State of Wisconsin versus Jessy Kurczewski, case 21 CF 885. May have the appearances, please.
Good morning, Judge Randy Sitzberger, Abby Nikolai, and JJ Crawford for the state.
That's better.
Clerk Pablo Galaviz appear with Ms. Kurczewski. Good morning.
All right, good morning. We are here this morning to conduct the jury instruction conference. As the parties should be well aware by now, the court worked on a draft of the jury instructions until almost 6:30 last night. Madam Clerk emailed those to the parties. There are some questions in there from the court as well. I highlighted a couple of things. And of course, we also have the request and the motion from the defense for a lesser included instruction on assisted suicide. And then Attorney Galaviz, I believe, emailed everyone, and then Madam Clerk printed it off for me, a request for a special jury instruction as it relates to count 3. First of all, has the state had an opportunity to review the draft that the court sent yesterday?
Yes, Judge, I have.
All right. And how about the defense?
I have.
I'd like to at least get through the issues that are not contested. And we'll just page through this, and then if there are things that are contested, I'll just put an asterisk, and then we'll circle back to those. Starting with page 1, this is the standard introductory type language. Then it goes into the 3 counts. The court, simply based on a request prior to trial with a question, is this being requested, also included the bridging instruction. A different version of first degree intentional homicide that had a bridging instruction with first degree reckless homicide. So I don't know if the defense is requesting that at all. Is there a request by the defense for that?
No request for reckless.
No request for reckless?
Well, I mean, not at this point. I mean,
Well, you need to tell me now. I'm not piecemealing this. So if you're saying, because what I hear you say is, well, no request now, but if I deny your request for assisted suicide, we're going to request it. So you need to tell me now what the requests are.
Just one moment. Let me
Sure.
Talk this over for a minute.
Thanks, Ryan. Okay. Thanks. Wisconsin. Yeah. Oh. Okay.
Oh, good, because I.
Just a reminder, this is a video I made just before coming live. Take a watch it later or now, whatever you want.
If you want to hang out, you can too. Have a seat next to Teresa in case. I don't know, do you have a laptop?
I do. Yeah, go grab it and come back down.
That'll be good.
Great.
All right, Attorney Kukler, is there a request for a lesser included of reckless homicide?
I just have a question for the court. If I say yes to that, that doesn't preclude you're not going to take that into consideration, are you? And preclude, I'm not saying you're agreeing to an assisted suicide, but by agreeing to a reckless, that doesn't preclude us from having a third option of assisted suicide.
I just want to know if there's a request from the defense, because this was raised prior to the start of the trial, where the defense asked that I instruct preliminarily on reckless homicide. I think the case law tells me that to primarily consider lesser includeds upon request. So really my question is, are you maintaining that request or no longer requesting the court consider a lesser included of reckless homicide. I understand there's trial strategies involved, and I don't in any way want to interfere with that. I just don't want to piecemeal this going forward.
Right, but from my perspective, from the defense perspective, I think I'm requesting that we come back to this decision depending on how the court rules on the assisted suicide, because you can't piecemeal it. And asking me to give an answer on the first, on the reckless at this moment, when we don't have your decision on the assisted suicide, feels piecemeal in a way. And so I'm asking whether or not we could deal with the assisted suicide, and then we could make a decision on the reckless. I'm not sure why we need to do it in the order that you're suggesting. Makes it very
I'm
difficult.
just simply asking if there's going to be a request from the defense related to reckless homicide and whether this court should consider it as a lesser included offense.
Well, I will say this. If the court denies the request for assisted suicide, we would request the reckless. If the court agrees on the assisted suicide, we would not want the reckless.
State have a position on that?
I'm fine circling back to it, I guess, if we need to, if that's a cleaner way of handling it.
Okay, so I'll put an asterisk on that.
Common sense, like, of course you've got to circle back to it. What's the judge doing?
Anything about the language of the first degree intentional homicide jury instruction that is included on page 2?
I didn't see anything wrong with it, Judge.
Nor did I.
Okay, we'll just for now skip over pages 3 through 8 because that is the a different version of the intentional homicide with a bridging instruction and reckless homicide. Then the second count, which starts on page 9. Any issues on page 9 from the state,
Not that I saw, Judge.
from the defense?
Agree.
Same thing, page 10.
On page 10, just under sort of the middle of the page, under the third count, it has, oh, I'm sorry. I thought it looks all right. Sorry.
You know, the defense has submitted some special jury instruction, but I'm not clear as to the basis for the request legally and where practically in the instruction the defense is making this request. I don't necessarily want to argue this at the moment. I just kind of want to know where you saw it fitting in.
Attorney Galaby's drafted that, but I believe that he would, maybe he should speak to that, but I believe he wanted it under element 1 as a definition. Go ahead, you can speak to that.
That's correct, Judge. As far as defining property of another, I was hoping to, well, I was requesting that the court place the language in the special jury instruction in that location, defining what is property of another.
Right, so I'll make a note on that and we'll circle back to have a more full discussion on that. But other than that, would the language on pages 9, 10, and 11 as it relates to count 3 be approved?
Yes, from the state.
Yes.
All right, then information, not evidence is pretty standard. Burden of proof, as you can see, just based on a comment that was made by the state off the record, you weren't going to take a position. That might have been on the record, I'm not sure. I highlighted the word must. Is the state still not taking a position?
Sorry, I was doing other things. So basically, this is just the jury instructions conference. State and defense have both rested. Rebuttals happen. We got on Monday. We have closing arguments and basic jury instructions, and then it gets given to the jurors. So yeah, that's it. Monday is everything now. Nothing else happens today except for this jury instructions. But I know that a lot of you want to hear about some of the definitions of words, so that's why I thought, you know what, I'll stream it. I think it's quite interesting for some of you. So yeah, so here we are.
Position on that?
I don't object to how it appears on page 12.
All right, and is that the request from the defense?
It is, Your Honor. Thank you.
All right. And I only changed that one word. That's my understanding, is that proposed 140 that'll take effect in January only did that. Is that your understanding, Attorney Kukler?
It is correct. That's correct.
And that's your understanding as well, Attorney Sitzberger?
Yes, and I did compare the two word for word, even the comments yesterday. That's the only change, is that one word.
I did the same.
Excellent. Okay. Evidence defined. That's standard. Any objection to that?
No, Your Honor.
No, Your Honor.
All right, then I put together the agreed facts instruction based upon my memory of what was discussed. And that is literally just that 2 paragraphs on page 13.
Hi, Hannah.
Every word.
Sorry, Hannah, I was behind the scenes doing stuff. Hello, Hannah. Hope you're well. Welcome. And shout out as well again to Chris Miller, who renewed their membership. So thank you, Chris. If you're, well, probably not here, but thank you, Chris, for that. Been a member for now for 3 months. So thank you, Chris.
It a little bit just because I thought it read a little bit better, but I'll hear from the parties on that one from the state,
I have no objection to how it reads.
from the defense.
It reads well.
All right, so you approve.
I approve.
Thank you. Then going on to page 14, we have circumstantial evidence, motive, and the start of credibility of witnesses, just as the first 2. Any objection?
No.
No.
Credibility of witnesses. Any objection to that from the state
No.
defense?
No.
Then going on to page 15 at the very bottom, impeachment of witness prior conviction, and goes on to page 16. Any issue with that from the state,
No objection.
from the defense?
No objection.
All right, then the court drafted the next one. It is a cautionary instruction based upon evidence of other conduct. The first question would be, is the defense making any request for a cautionary instruction regarding the other acts evidence that was presented?
Yes.
All right, and then I drafted this pretty generally.
Terry.
Do you take any issue with any of the verbiage or have any suggestions for the court?
So, no, the verbiage is good. The only thing I would ask is that when these go back to the jury, that there's a bit of bolding.
Oh, that's just my highlights. So when you saw it electronically, you knew that those were questions I had for the parties. That will, of course, be taken out.
Okay. So
As you approve it, I'm taking the highlights.
oh, okay, great. Because even when I printed it, it showed up. So, okay.
Yeah, no, I just wanted to sort of direct you to things that I thought warranted a further discussion. Those will absolutely be taken out.
I think Attorney Galaviz just pointed out that the only thing we would ask for on that is that we add the year 2010.
For both, I gotta look at
They were both in
They were-
2010.
Okay.
They were both were.
that. So looking at where it says specifically, comma, evidence has been presented that in 2010, you would ask me to add that?
Yes.
Any objection?
No, Your Honor.
How about from the state?
The only issue I saw is that the court has listed issues of motive, intent, and absence of mistake. And I think when we looked back at the transcript in meeting with the defense to talk about jury instructions, I believe the court's order for other acts was for motive, opportunity, and absence of mistake. I don't think it's the biggest deal in the world, but just to keep the verbiage the same across court decisions.
I was going off of memory and then I realized I had the transcript and I unfortunately kind of ran out of time looking at it. What's the defense position? Do you recall the court also indicating it was permissible as to opportunity
Yes, I think a not intent.
and not intent?
Right. I think it was mode of opportunity and absence of mistake. Am I right about,
I'm sorry, there was also context and background as a permissible purpose.
So I, now having heard the testimony, it was very small in comparison, right, with the evidence on the case as a whole. I don't know that it really goes to context anymore.
That's fine. I was just trying to make sure
Or back, and I would also say that as to background, because it's been utilized from my perspective, and the state can correct me if I'm wrong, as to this motive, intent, and absence of mistake or accident. I'm not sure it even applies to opportunity at this point, just given, but I'll hear you on that if you want me to include it.
I guess I don't know what it would look like taking out the intent. So further below under definitions, I'm not sure, and I'd have to look at what opportunity would read there. I'm not asking the court to include anything on context and background. I think that gets very confusing when you then tell the jury they can't use it as far as conformity and things like that. So I really only brought that up to complete the record from the court's decision.
I think intent is appropriate. But I have to look at the transcript if I included that, but
In looking at 275, opportunity would read, quote, opportunity, comma, that is, comma, whether the defendant had the opportunity to commit the offense charged.
and these would be the theft charges. So I'm not sure, especially given count 3 is from an estate. So I think that it distinguishes it. I think it's cleaner just to include these, but
To be fair, I'm fine with how it reads on page 16 into 17. So I'm fine leaving it as is. I just wanted to make sure we were all aware that the original decision had slightly different language.
what's the defense thought on that? Just keeping it as is, changing it in any way, given my earlier decision?
right. As we're talking about it, I just don't have the transcript in front of me, but I didn't recall the court saying that it was going to come in on intent. That's the only question I have at this moment. And I apologize, I don't have transcript along with me today.
This is long drawn out, isn't it? It's weird how they, it's not weird, but you could argue over every single word, basically.
I know I had a long discussion, not long, but a discussion about intent, its relationship to motive.
Mhm. Mhm. No, I understand that. No, I understand the
I
wordings
know
before.
initially I talked about
I'm just saying how funny it is. We have to
motive.
argue about every single word.
let me
I
just
got
pull
it.
apart. The purpose of motive, opportunity. So nope, not in the right spot. I said they were compelling, but then I went through an analysis of intent. And if I didn't state it specifically, I was specifically referencing that as a permissible purpose. And so, and given the testimony that the court heard, I think it's appropriate to include motive, intent, absence of mistake or accident, and then leave out the context and background and even opportunity. So I'll revise that ruling based upon the evidence that actually came in and the permissible purposes that are available to the court, my prior ruling, and again, kind of tweaking it based upon the evidence that was actually received at trial. So that part will remain as is. All right, then page 17, statement of defendant. Statements, it says plural. This is a standard instruction. Any objection from the defense to that?
Well, I'm sorry, just going back on page 16 though, paragraph 2, specifically evidence has been presented that in 2010, you're going to add the defendant, it should say attempted to obtain a car title loan. She didn't actually obtain it.
State agree with that?
Yes.
Okay, thank you for that clarification.
I'm gonna share it just so you can see.
It's okay, we'll just do it. Attempted to obtain a car title loan at a payday lending store by using someone else's personal identifying information and attempted to open a savings account in the name of another person. All right, thank you. All those corrections and changes will be made. And then going on to page 17, any objection to that from the state?
No.
From the defense, this is specifically statements of defendant?
No, we asked for that.
All right, so moving on to page 18. So this is the defendant elects not to testify. I included some of the cautionary language from other things that came up. Not sure what the parties' positions are in terms of location, content, and any type of heading, but this is where I included about hearing testimony and seeing evidence about the defendant being in custody, that's not to be considered. It must not influence your verdict. I struggle with that a bit because I know some of the evidence and perhaps argument I think ultimately that will be made is that one particular document, that second will, was sent while she was in custody. So I don't want to mistakenly tell the jury that her custody status doesn't matter at all. It's really that it doesn't mean because she's in custody, she's guilty of something is really what I'm trying to get at. So, and then I included about the defendant,
Hi, Mike.
Lynn Hernan. The jury heard a statement that they were felons. And I included language about that. So because these are cautionary, I think it's important that the defense actually request them or agree. And what I've added really come after the first two lines, which are separated by paragraphs, but the first two lines make up the standard defendant elects not to testify. And then it's the third and fourth paragraphs that I've added. So,
Anyway, hi Mike, first time to the channel, so Mike Kick. Lovely to see you. Thanks for being here, Mike. Appreciate you popping in. Yeah, just hang around, talk crap. It's all good. Got lovely people here. So thanks, Mike.
so go ahead.
Okay, thank you. I like everything that the court has written in here, and we do want it. I'm just not certain that paragraphs 3 and 4 should be under the heading of defendant elects not to testify. That's my only concern about it. Because I really...
That's why I had the question.
Yes, right. And I prefer that the defendant elects not to testify just be its own. And then maybe since all of these have a heading, I don't know, maybe just could be a separate. Not sure what we would call it.
That's kind of where I was at yesterday. But all right, what's the state's position on this language?
So I don't have any strong objections. I personally would do away with paragraph 4 and not highlight one statement in a 3-week trial revolving around Ms. Hernan, but obviously more importantly, Ms. Kurczewski being a felon. But if the defense wants that in, I don't object to it. I just personally think it highlights for the jury one statement, again, in voluminous testimony. As far as putting it somewhere separately. I think you could. I think later on we'll see a cautionary instruction about referencing jurors by their number. We could simply call this a cautionary instruction as well and separate it that way.
So I don't disagree with that. That could be a good title for it. I think it flows well, so I would ask that it remain in this location. You do defendant elects not to testify, and then maybe we move to a cautionary instruction because they do relate to some extent, just a little bit. But I agree with the title of cautionary instruction.
Any objection to that, Attorney Sitzberger, that I just put that heading cautionary instruction right after defendant elects not to testify, meaning that section, leave it there with the language because the defense has approved of it and you're not taking a strong position.
That's fine with the state.
Okay, then we'll do that.
Where you from, Mike? Where you from? Where you from, buddy? UK, Canada, US, Australia?
Yep. All right, exhibits, objections of counsel, evidence received over objection is, of course, very standard. But any objection to the verbiage?
Oh, you're on.
No, it's standard. Thank you.
Bills, Bills, Bills. Buffalo Bills. Happy days. Josh
Same thing,
Allen.
improper questions, stricken testimony, weight of evidence, remarks of counsel, those are all standard. Any objections to those on pages 18 and 19?
Oh, you're on.
No, Your Honor.
All right, the precautionary statement on numbered jury. Does anyone want that in? I expressed this to the jury, of course, at the beginning of voir dire. I included it just in case you all thought it was important from the state.
I
No.
don't want it in personally.
I agree with that. I don't want it in.
Don't want it in? Okay.
But to be fair, the Bengals are a good side. So you'll be all right. You'll make the playoffs. You'll be fine. You'll be fine. Josh Allen and Diggs will get. And Gabe Davis, he's good as well. I like Gabe Davis. I think you'll be fine, Mike. I think you're going to be fine, sir. I can't wait to see the snow come out on the Bills, though. Last year was epic, seeing all that snow you guys had. But anyway, welcome, sir. Thank you for popping in here. Thank you for chatting as well. We love it when people chat.
Okay.
So yeah,
And by
carry
agreement,
on.
I'll take it out.
David. Third round, I remember when he was picked, he was like, what, are you tough or smart? And he was like, tough. And they're like, well, so you're not smart? And he goes, no, I'm smart as well, but I'm tough. Third rounder, good pickup. Good pickup.
Jurors' knowledge, expert testimony general, and expert testimony hypothetical questions and closing arguments of counsel are all standard. Any objection to those from the state,
No.
from the defense?
No objection.
The closing instruction is standard. Of course, I drafted verdicts based on that reckless. That was by no means in any way suggesting that I agree it should be in or not. I just wanted to have it there just in case, because it takes a little bit of time to draft those.
So as to the verdicts, the only suggestion on the forms of verdict would be that you read the not guilty option first before the guilty.
So if there is a lesser included, the pattern tells you to go through the guilties and then the not guilty, and then they actually answer it on a form. I'm not sure we had sent over what the verdict forms look like, but there's a line and they have to check it off, and there's a very specific instruction. If it's a standalone, I always put the not guilty on top of the guilty in the packet when it goes back to the jury. As you can see, counts 2 and 3 really read through that. We'll kind of hold off on verdict for count 1 at the moment because we obviously need to decide some of these other issues first. But what about the verdicts for counts 2 and 3 and the special questions?
The only change I would request is that instead of referring to it as intentional transfer of movable property, we just call it theft throughout. think that's the verbiage we've used this entire trial. And though an element tailored to that theft is the transfer of movable property, I think the actual crime that's been referred to a number of times is theft.
What's the defense position?
I think it's correct as you've written it.
No, yeah, it wasn't Mike, it was Terry, man. No, yeah. Terry, they're asking for him to be recused from everything. So he can't be. It would be diabolical if he's now involved in anything with Murdoch. But he still is technically, but it'd be absolutely diabolical. Everyone thought it was a bust, but I told them everyone thought that would be Darnold ahead of Josh Allen. Do you know what I mean? But it turned out, no. Josh Allen's the man. I've actually no idea. Thierry, no, he is. There's a motion to have him removed. I've heard he's supposed to retire at the end of the year. He's supposed to, yeah. Sorry, no, yeah. Fuck! He is. He's a beast. He's the best quarterback from that group. Oh, is he? Which one's Mahomes in? No, Mahomes the year before him, yeah. I think some people say the Lamar's
I
better.
was looking
but I
back
think it's
over
Josh.
at the theft jury instructions, and they do. So the charging language says did intentionally transfer movable property of Lynn Hernan in count 2, and then the estate of Lynn Hernan in count 3, and then the values that have been alleged, because the statute requires that there be a selection. There's multiple ways to violate the theft statute, but the crime itself is theft. And then it says statutory definition of the crime, theft as defined in. So I believe that that is more appropriate to include, or just to reference it as theft. I think it would be also accurate, though, to say theft of movable property, since that's part of the specific allegation. So I'll take out the intentional transfer of and just put theft of.
I'm sorry, Sarah, but it's my mic. It keeps going up. It's uncontrollable. It's like I take a Viagra. It's like it's taking Viagra.
Of movable property. And then the first one having a value that exceeds $100,000, and then theft in the second, in count 3, having a value greater than 10,000 but does not exceed 100,000 is charged in count 3. Any further discussion on that from the state,
No, thank you.
from the defense?
It looks, I guess if that's how the court wants to do it, that's no strong objection to that.
Okay, thank you. The bottom part of page 23, the last paragraph, is the standard verbiage about determining guilty or not guilty for each of the offenses charged, making a separate finding, and that your verdict for one must not affect your verdict on any other count. Any objection to that from the defense,
No.
from the state?
No.
And then it has the standard verbiage on unanimous verdict and selection of presiding juror and instruction after verdict. Any issues with those from the state,
No, Your Honor.
from the defense?
No, thank you.
All right. Then just moving on, some of the things that I included is anyone requesting 201 opinion of a non-expert, and if so, on what topic?
The state is not requesting it specifically because I think it would involve many witnesses and declaring what their opinion testimony was. And I think it would be distracting and confusing to the jury to go through all the witnesses.
Attorney Kukler?
No, we don't, we're not asking for it.
All right, 201 will not be included. And then I'm not going to go through the assisted suicide just yet, just pointing out 520 is the Allen instruction just in case it's needed. I just wanted you to have the verbiage. And there's some suggested form for polling the jury so that you all would have that in the event that is requested. I typically don't follow that verbatim when there's multiple counts, and I sort of combine them together, but at least you have the general idea. I'm not going to go
That's, if you didn't know, that's Jesse's mother. Jesse's mother there. I don't remember her name now, but that is her.
through those with specificity, just there for reference later on, should we need to include those, okay? So let's now turn to the defense request for the assisted suicide instruction and whether it is a lesser included that this court can consider. Either is it a lesser included, or even if I assume that it is it appropriate in this case? So since it is the request from the defense, I'll turn to the defense first.
Yes, thank you. We are asking the court instruct on assisted suicide. There is, so first of all, we do feel it is a lesser included offense because it falls in the 940 chapter. And that is all of the homicide crimes. And we've outlined our position in the motion that we filed. The Court of Appeals hasn't directly answered the question because they were able to dodge it a couple times. We've seen it.
Exactly my word.
Oh, we've seen
They
it.
dodged it.
They kind of dodged it a couple times. We've seen it come up saying there wasn't a colorable argument that the jury could find the defendant not guilty of first degree intentional, but guilty of the assisted suicide. I think it's absolutely the case that it's a lesser included based on it being part of Chapter 940, combined with the State versus Chapman case that we cite in our motion that held that all forms of homicide are a lesser included of first degree intentional. And the statute in the cases say that the difference in elements doesn't matter when we're dealing with lesser included of first degree intentional homicide, unlike other crimes, because it's specifically carved out in the statute as a special category.
So let me just ask some questions about that.
Sure.
And is it truly a homicide? Is it just by virtue of, 939.66 sub 2, I believe, is it a homicide? When you look at the elements of assisted suicide, the distinguishing, I think, factor that I need to consider is that assisted, or part of the elements of assisted suicide is that the deceased commit suicide and have the intent to commit suicide, and that the defendant in this case would have needed to provide assistance with the intent that the victim take her own life. Whereas when you look at homicide charges, it's always the life of another. There's a third party actor, if you will, right? It's not the victim whose intent matters in any of the homicide allegations. And even though it's in 940, it's really under the heading dealing with life. And I know we're not bound by headings per se when looking at the statutes. 940 is broader. It's crimes against life and bodily security. And while it's, again, under that heading of life, shortly before the subchapter on bodily security, there are things in there that are broader than or different than homicide. But so any case law. I know Wisconsin doesn't have anything definitive, right? As you said, the Court of Appeals really dodged it. Our Supreme Court hasn't answered it, but any other persuasive case law you can point me to, or any other argument on, is this truly a homicide because of those distinguishing, what I would call, factors?
I appreciate that, and I don't have, I mean, we've searched really, and I don't find anything that is right on point. But like the court pointed out, Chapter 940 is a large chapter, starting with 940.01 and going all the way to 940.49. But assisting suicide is under the life subchapter Roman numeral I, which suggests that that it is considered in the category of homicides. It's mutilating a corpse, assisting suicide, abortion, partial birth abortion.
Mutilating a corpse would never be a lesser included, though, of a homicide. And I think that's pretty clear. And so just to simply say that it's in that subchapter, I don't think is persuasive or definitive.
Well, and to your other point, of course, during the trial, Dr. Thomas testified that it could have been a suicide. So as to the question about whether there's evidence in this record that the defendant provided assistance to Ms. Hernan and that she had an intent to take her own life, there is evidence in the record taken in the light favorable to the.
But what's the evidence that your client had the intent to assist Lynn? When her own, I mean, obviously she didn't testify. We had a lot of her statements come in. And the one that comes to mind the most is, I didn't think it was going to kill her, that she repeatedly says to detectives during her interview.
Right, but it just depends on which statement of Ms. Kurczewski you pay attention to. She's gave many statements during her interviews. And of course, she did indicate that at one point she knew that Lynn was suicidal. And
I understand what you're saying, but I think that goes to the intent of the victim. And the real issue is there any evidence? I'm kind of jumping to the second prong of the inquiry, though, that even if I assume assisted suicide is a lesser included, is it appropriate on the record before the court, because of the statements made by your client, that she never thought this would kill her? She got sick in the past.
Well, you can't pick one of Jessy's statements and take that one alone and not consider that there's a variety of statements.
Well, like what?
With the evidence in her statements is that she gave her a bottle of water and that she put Visine in it.
Who put Visine?
Lynn. That Lynn put Visine in a bottle of water and Jessy handed her the bottle of water.
But Jessy was very clear. She never saw her do it, other than in the past putting herself 2 drops in. She was stating that based upon Visine bottles that she reported were in the garbage that she threw out 3 days prior.
My recollection is there's one of the statements where Jessy said that she gave her a bottle of water that she believed had Visine in it. And that, yes, Lynn had put the Visine in days earlier.
And I think there was some other testimony through the interviews that she could tell it was different because there was some oily substance.
And not only
So,
that,
but I'm going to still press you on this, though.
Could I
But
reference?
knowing that it was in there, even believing that the victim's mental state was at issue and she was, depressed or frustrated with her medical condition, what can you point me to that would show that and this is element 3 of the assisted suicide statute or element, the defendant gave assistance to the victim with intent that the victim take her own life, meaning that the defendant had the mental purpose that Lynn Hernan committed suicide, or that the defendant was aware that her conduct was practically certain to cause Lynn Hernan to commit suicide.
Well, it would be an ongoing, well, first of all, a couple points. One, I want to remind the court about the state's own presentation where investigators believe that Lynn's in
Oh, for fuck. Sarah P, happy birthday, Sarah P. I forgot everything. Sarah P's birthday today, everyone. Sarah P, happy birthday. Happy birthday, Sarah P. You can hear me now, Terry. Sarah P. It's a birthday. I cry if I want to. Cry if I want. Right, here we go. This is for Sarah P. Pen blwydd hapus i ti. Pen blwydd hapus i ti. Pen blwydd hapus i Sarah P. Pen blwydd hapus i ti. Hip hip hooray! Hip hip hooray! Hip hip hooray! There we are. Sarah P got her special song. Congratulations.
in their interviews of Jessy,
Congratulations.
time and time again, I think I made note to myself of how many times they suggested that this was an assisted suicide, and they believe that Jessy assisted her, that Lynn wanted to kill herself, and that Jessy wanted to assist her. So that was, the jury heard that time and time again. There must be 6 references to that.
That doesn't mean that's your client's state of mind.
Well-
Them trying to elicit a confession out of her based on that is really not dispositive. It's her responses or lack thereof that are more dispositive on issue. I need to look at the evidence in the light most favorable to Ms. Kurczewski, but it still brings me back to, you got to be able to articulate on this record, what is the evidence to support element 3 and thus make it appropriate, even if I assume, without deciding the first question, but just assuming for purposes of this discussion that assisted suicide is a lesser included, I still have to determine whether it's appropriate on the record before me. And there has to be some evidence or reasonable inferences from the evidence, right? That Ms. Kurczewski gave assistance to Lynn Hernan with intent that Lynn Hernan take her own life.
So a couple of things, again, I want to mention is that besides the investigator making those comments to Ms. Kurczewski, how about her response, Judge, where she says, well, either way, then I'm going away for a long time. So it's like a resignation that they were correct. That's how I interpreted that interview when I saw it and watched it and saw it replayed. So there's that. Also, I don't want to lose sight of the fact that another allegation here in the suggestion that's been made during the presentation of the state's case was that the state say or suggest that Jessy bought guns for Ms. Kurczewski, or for Ms. Hernan. And so again, going back also to the first part of what the court was asking about, like in any of the homicides, the ultimate result here on an assisted suicide is it results in the death of the victim. And it requires assistance, and it plays a role in the loss of life. So just like in homicide, the consent of the victim is not a defense. But here is actually an element here.
Anything else you want me to consider before I turn to the state?
Well, I think there's evidence of suicidal ideation, and there's evidence that Jessy knew of Lynn's illness. The state of mind really can only be determined by contextual evidence. And there, you know, we can't pick and choose Jessy saying one thing and Jessy saying another thing, but to look at it all, everything that was presented here.
Agreed.
Right? Okay.
And I wouldn't even dispute that on the record before me, there's evidence that would support element 1. I think you could look at Dr. Thomas, you could look at, you know, the toxicology reports. I think I'm not worried about that one. It's really, did the defendant assist Lynn Hernan in committing suicide? And did the defendant give assistance to Lynn Hernan with intent that Lynn Hernan take her own life? It's with the intent part that I'm most concerned with. So
I think under one, you know, looking at the evidence, one way the jury could look at this evidence, Judge, would be that Lynn and Jessy had a very long, almost lifetime mother-daughter relationship, a very close relationship. And so,
but how does that show that Jessy Kurczewski had the intent that Lynn Hernan commit suicide?
well, somebody who has a lifetime relationship, a loving relationship with somebody, and they know they're sick and they don't have a desire to live any longer, because there's been testimony in this record of that is reasonable to assume, and jury could assume that somebody in a Jessy role might want to assist. It's kind of like when we were in voir dire, one juror who ended up being excused said, hey, listen, this is a complicated matter for me, because I think that if I love somebody and they want some assistance with that, I think I would probably provide it, something along those lines. And I think based upon how the evidence came in here, a jury could see Jessy and Lynn in that same light.
You would agree, though, that really the only evidence related to the intent of Ms. Kurczewski would be her own statements that came in through the course of the interviews or anything she may have said to anyone else. But I understand, and when we look at intent, right, it's the facts and circumstances surrounding, it can be circumstantial, but primarily we're looking at, I mean, right, no one else can say what Ms. Kurczewski's intent was. This jury's going to have to decide that, but there has to be some evidence of that. And so, you know, whether the victim intended to commit suicide, meaning part of element 1 and really, which is part of element 1, I agree. There's some evidence there when taken in a light most favorable to the defense. It's really the elements 2 and 3, and primarily element 3. So let me hear from the state, and I'll give you the last word on that.
Okay, I just want to I forgot to mention to you that also there's evidence that Jessy bought Visine, that she would bought all these bottles of Visine, and there's that suggestion that she did know what the consequences of THC tetrahydrozoline were, because the state presented evidence of texts between Jessy and Scott Craig in January, before cause of death has been determined here, that showed that she had some knowledge of it because she discussed it. The drug name is the way the state brought it out, the actual name of the drug, tetrahydrozoline, and she brought it out with Scott Craig before that was even ruled as a cause of death.
All right, thank you. I'll hear from the state.
Thank you, Judge. So the analysis this court should go through is really, I think, should focus on the first prong, and that assisted suicide cannot, by definition, be a lesser included first-degree intentional homicide. I think the defense is misconstruing 939.66 sub 2 for the premise that anything under subchapter 1 of 940 is a lesser included. This court has already correctly pointed out that 940.11, mutilating or hiding a corpse, is not a lesser included of any homicide. And just as similarly, assisted suicide is not. Part of this trial has been sort of painstakingly going through the legal difference between homicide and suicide. They are very different things. So when 939-66 sub 2 talks about a less serious type of criminal homicide, it's really limiting to just those top sort of half of crimes listed in subchapter 1 of 940 that are homicides. To declare otherwise would lead to an illogical ending whereby the state, really in any homicide case, would have to prove beyond a reasonable doubt that the defendant took the life of another. But if the defendant merely brought up the fact that the victim wanted to die, the state would now have to also prove beyond a reasonable doubt that the victim killed themselves, because that's what we're dealing with here. If you allow this as a lesser included, somebody has to prove to this jury that Lynn Hernan took her own life and had the intention to do so. And that's certainly not what we've proved. And I'm certainly not making the argument that any burden shifts to the defense to prove element 1 of an assisted suicide, but thereby is the illogical nature of this argument claiming it's a lesser included. And so when we see under 939-66 sub 2 that it is not simply because it's a death, it's not a lesser included of any homicide, it's not a criminal homicide at all, to say an assisted suicide, then we have to go back to the Blockberger elements test, which is to say, is there any element of the lesser offense that would need to be proved that wouldn't otherwise have to be proved for the charged offense? And here very clearly there is. That's that illogical nature of now the state has to prove really both that the defendant took the life of another, or somehow make this completely 180-degree different argument that if you don't believe that, then you have to believe the victim killed herself, and we have to prove both of those things beyond a reasonable doubt. It just doesn't make sense. I agree that there is no Wisconsin law on point. There's a 1996 case that's unpublished that just historically, again, as I think the court mentioned, declined to decide on prong 1 and went right to prong 2. I did find one American Law Journal article from 1985 that sort of summarizes a number of states dealing with this. I can tell the court that their summary of their review of a number of different states dealing with this issue really led to, there is no uniform conclusion, but what a lot of states that are referenced, and then I can email it to the court and parties, but what a lot of states have even found is that they've upheld murder convictions, even in cases where a defendant and the victim entered suicide pacts together, and one was, I hate to say this, but successful in committing suicide, and the other attempt either didn't go through or was unsuccessful. That person was still convicted of murder as opposed to an assisted suicide. So again, under prong 1, and I understand what Attorney Kukler was saying as to prong 2, but I think it's important to remember for prong 1, whether it's a lesser included just on its face, does not deal with any of the facts that came out at trial or any of the alleged conduct. It simply deals with the language of the statutes on whether something can be considered a lesser included. I don't think this court even needs to go to prong 2 because of the illogical situation that would be set up if we call this a lesser included and sort of the unreachable burden the state would have to face between the two. But if we do reach phase 2, I would say that even the expert the defense has brought in was not able to a degree of medical certainty, call this a suicide. She was undetermined. And so she couldn't tell this jury whether it was a homicide or a suicide. So there's no evidence aside from Ms. Kurczewski's statements about Ms. Hernan, that this was, in fact, a suicide. It's not as though they brought somebody that said, I would have determined this is suicide. Undetermined is the best we have. So if we get to prong 2, I would highlight that there's no solid evidence which the jury can go on right now to lead them to believe anything about a suicide. And I understand for lesser included, it doesn't have to be beyond a reasonable doubt. There has to be a reasonable basis. I would agree with everything the court said on the third element. But again, I don't think we have to get past prong 1 because this is not a lesser type of criminal homicide and it does not pass the elements test.
Attorney Kukler, anything else?
I mean, well, Ms. Kurczewski wants me to mention to the court, and it is it's a fact of her life that she was revoked for assisted suicide. And we did, of course, sort of quasi talk about that, although possibly not with the jury. But she was revoked for that.
Well, it was not talked about in front of the jury, number one, and number two, the burden of proof at a revocation hearing is very different than the burden at a trial. And so that has, I understand why it's being brought up, but it has no bearing on what the court's doing today.
So first of all, yes, I would like to respond. I would indicate that I believe we're entitled to the instruction if a reasonable jury looking at the evidence in the best light for Jessy could find, not that they must find, but if they could find it. And just like we don't need to specifically identify the evidence that meets each element of a crime, if the jury could find based on some combination of the evidence, we don't need to specifically identify the facts in the record that taken together would certainly be enough. And I don't think the court is permitted to weigh those statements. Someone has to decide here on less than clear evidence. Due process requires that the jury do that, not the court. And if the jury thinks it's not fully supported, they'll come back not guilty on it. I mean, precluding that option where here there's evidence that even the state believed it was assisted suicide based on the investigator statements throughout the part of investigation would be wrong. And as far as the argument on these other states, those states likely have very different statutory language. I don't know what is, the statutory language in any of the states that's being referenced by Attorney Sitzberger, but they very likely have different statutory language about lesser included. And without the context of that statutory language, there we can't really give weight to another state's practices regarding charging something as a homicide versus its own crime. And undetermined doesn't rule out suicide. It doesn't rule in a homicide. I think the statute's obscure enough that we all reasonably disagree on the meaning. And I think also the rule of lenity should apply here. Lenity should apply here. I think assisted suicide is arguably a homicide in medical examiner terminology. And I think we give the benefit of the uncertainty to the defendant, Ms. Kurczewski.
So I want to take this under advisement, given some of the information, the arguments that have been made. I've had my law clerk looking at whether any other state has done this. And similarly to Wisconsin, sometimes the direct question isn't answered because it's not appropriate in any given case. And I just want to kind of digest the arguments of the parties and formulate more of a decision that I think references the law that I need to reference. It won't be long. I'm not even going to step off the bench right now. I want to think about this more. This is a novel issue in Wisconsin. We have no case that is directly on point. And I think both parties raise some very good arguments in terms of, for example, from the defense, whether it's a homicide charge, because if I consider it a homicide charge, it really doesn't matter what the elements are. That's pretty clear in the case law. So I need to answer that initial question is this a homicide charge? Meaning, is assisted suicide a form of homicide charge? I do not think that being in the subchapter that it is dispositive in any way, primarily for what I've pointed out already, and that is there are other offenses in that same subchapter, like mutilation of a corpse, that would never be a lesser included. And so that's not dispositive, but I want to give it a little bit more thought. I didn't have the benefit of the state's position yesterday. And so I'm just going to move on. I may very well want to think about the arguments the parties have on this theft issue as well, and the request that's there before I give a definitive.
Hi, Christine. Thank you for being a member for 2 months, Christine. Thank you very much.
Answer. So let's turn to, and let me get the arguments of the parties on this special jury instruction that the defense is requesting in terms of a definition, if you will, to provide to the jury on really on what the meaning of another means, because we already have the definition of movable property in the jury instruction. It's property of another. Now, so Attorney Galaviz, the charge here in this case is that it's the estate of Lynn Hernan. And my initial thought when I read this is, if I assume that that second will is valid for purposes of this discussion, and that Jessy Kurczewski is the only beneficiary, and she's convicted of homicide, she can't legally be.
I can't do this today, lovely. Abby just had me around my face and broken my phone. Oh, no. No worries, Emma. We'll see you tomorrow, hopefully. Don't worry about it. It's all good. Love you too, Emma. Love you too. Hope you get your phone fixed. And hopefully we'll see you tomorrow for Matt Moore. Catch you later. Take care of yourself, Will was here for you.
The beneficiary. And if there's no one else, that means the laws of intestacy would apply. It doesn't mean that that Anthony Posa couldn't give, kind of undercuts your argument, basically, what I'm trying to say. So, so I just want you to think about that, and is your request even legally accurate, given how the laws of intestacy would really kick in under the scenario that you kind of dance around in this special jury instruction?
Subscribe to Christine.
Well, if she's not convicted of count one, then
Subscribe to
the
Ed.
argument stands if the jury comes back not guilty on count one.
What about this idea, though, that she has a fiduciary right? You have a fiduciary obligation as a personal representative. I mean, this is not a novel idea that personal representatives have been discharged from probate cases because of allegations of theft. This happens to be a criminal prosecution that includes that. So, I mean, you really are trying to kind of insert into the charge something that's not there. This idea that the estate can't be a victim.
Well, in count elements 2 and 3, they talk about the owner. Who's the owner of this property? You're saying the estate is, or Anthony?
I believe the estate is, but unless you can show me otherwise, I'm really concerned about the request that you've put forward, and even if and whether it even comports with the law.
Well, I don't think there is any law regarding the estate being the owner of this property in Wisconsin. I know you keep saying that the estate is, but I haven't found anything that says you're correct, that the estate is can be considered.
Well, what law do you have to suggest that someone cannot be charged with theft from an estate? Any case law in Wisconsin that says this can't be a charge as a matter of law?
Well, I don't think they can be charged in this particular statute. Maybe there's another statute that this falls under, stealing something from an estate, but I don't think this particular statute itself, a theft statute.
Why wasn't a motion to dismiss then brought at a much earlier stage in this game? I mean, I'm not saying you can't raise this now, but if that was truly the position, I think that was being taken, this should have been a motion to dismiss well before we ever had a jury trial on it. But be that as it may, the request is before me, and maybe I'll just ask the state. Does the state believe that the state can be a victim and that this charge is sufficient to go forward to the jury.
Yes, Your Honor, of course we do. Just like if a person goes into a bank and robs it, we don't try to figure out whose accounts that money was taken from. We say you robbed a bank. It can be a victim, just like a human being can be a victim. I think the entire length of this case, we've been clear that the estate of Lynn Hernan was the rightful owner at the time of these thefts. We've declared Anthony Poza a victim because he was the human entity that was set to receive some inheritance from that, and he was deprived of that because of Ms. Kurczewski's actions. But I think we've always maintained that at the time of the theft, this was a theft from the estate. That is another. And Ms. Kurczewski, certainly we talked a lot with both Mr. Nowakowski and
Hey, Carol.
Attorney Taylor of the fiduciary duty of a personal representative and their obligations and responsibilities for that very reason.
What is the state's position on the special?
You can also go and follow Carol's channel. I forgot Carol has a channel. So Carol has a channel as well. If you're into Minnie, Disney and all that, I think. So I forgot the other day that you have a channel, Carol. So there you go. Carol's channel's there. Please go support Carol. She supports me, so please go subscribe. I've just subscribed now. So have a look at all the Disney dreams.
Jury instruction language that's been proposed by the defense.
I object to it strenuously. I think it serves to only confuse the jury. It adds elements that, quite frankly, should have been brought before the close of testimony. Because if this were to be given, obviously, I would move to reopen testimony then and call Mr. Poza back to ask more specific questions. This really requires us to prove, I would say, elements. I know this is supposed to be an addition to an element, but specifics that we were not obligated to do under the jury instruction that was agreed upon at the start of this trial. And so doing this at the close of evidence is really unfair to the state to sort of ask the jury now to decide these very specific things that I would note are based really completely on a fraudulent will that has not been adopted by the court. It's been filed.
Carol, anyone that's a member of my channel that supports me, we support back. So thank you. Don't thank me, thank you for supporting me and being a member and everything like that. So least I can do is share your channel and ask people to support you. So Sarah P will add you to the list.
Filed, it's been received, but it has not been adopted by Judge Maxwell in the probate case. So it is not binding by any means, and this request only serves to confuse the jury as to count 3.
Judge, if I may
Go
respond.
ahead.
Regarding his fact scenario, there is a statute for bank robbery. It's under 94381 from a financial institution. So that's where you would go for his scenario when you rob a bank. This should have been charged under another statute, theft from an estate. Where does that fall? They always argued that Anthony Poza was the person in count number 3. When I asked him who's the victim in count number 3, and I was told Anthony Poza. And my position was, well, that's probably it's still open. So technically, he's a potential owner of this property. And
I think we're confusing now, and I'm just going to jump in right here about what the obligations of the state are under Chapter 950 versus what we have for purposes of this trial and the elements of the offense. So,
well, I need to fix that then, Jonathan. Well, my mic's up there now. So I need to fix that then, Jonathan. Echoey. I don't want echoey.
I'm not going to add to the statute when I have no legal authority to do that. My job is to apply the law, interpret the law, not to recreate the law, which is what I believe you're asking me to do with the proffered language. I understand what you're asking me, but I'm not going to do it. The issues related to whether an estate can be a theft can be a victim for purposes of the theft statute and can fully be raised on appeal if need be. You certainly can. This wouldn't preclude Ms. Kurczewski from raising any of this on appeal, and I think might be the more appropriate, or motions after verdict, if that's in fact what happens and there is a conviction. But I'm not finding support to insert this legal interest to property in terms of the elements. And where you want me to put this in, as was stated previously, is the under element 1, where it says the defendant intentionally transferred movable property of another between October 4 of 2018 and July 9 of 2019. It defines intentional, it defines movable property. I know right here it says the owner of the property. Perhaps we should instruct the jury the estate, or just leave it as is, because it was what was agreed to at the beginning, and we'll have to address any questions that come up later on. But it's my belief and position that the theft statute doesn't limit the state from including the estate as the owner and thus this charge. But I'm not going to insert this language that you have suggested, because it frankly is confusing. I believe it adds an element that's not presently in the standard jury instruction, and would require the state to prove something that is not a legal part of the statute, or meaning it's not part of the statutory violation. Unless you have some case law that says the estate can't be a victim and that it's just some glaring hole in our statutes, I'm going to include the language that's there without any further definition, and just simply take a wait and see approach if the jury asks any questions about that. I'll let you make any further record that you want on this.
I
Anything
don't
else?
want any of the other elements changed as far as the way they presently exist. So I'll keep it as it is, Judge.
All right. Anything else from the state?
Not on this issue.
Okay. So that will remain as is without any. All right. Other than the assisted suicide and then perhaps maybe the reckless homicide, lesser included, any other issues with the jury instructions I need to take up? Any requests for other additions or subtractions or edits from the state?
Nothing new, but can I circle back to the assisted suicide for one point I forgot that I thought of when the court was making its comments?
Hold on to that for 1 second. Just let me ask the same question to the defense. Any other edits, subtractions, or additions the defense is requesting?
No, but for the issue that was just raised on the count 3 requested instruction by the defense, I want the record to be clear that we're not agreeing to the standard instruction. We stand by our request for the special jury instruction. We understand the judge.
So I'm just having my dinner. Do you want to see my dinner? Jacket potato, beans, cheese, and bacon. So grilled bacon, jacket potato, cheese, and beans. Right, let's get on it.
The court is probably giving the standard one, but I want to make sure the record's clear. We're not agreeing to it.
All right. I think I took the agreement as understanding the court's ruling, the language as is. You're not requesting any additional changes.
Yes.
Understood. But I think that's good to clarify that for the record. All right, then you can go back to the assisted suicide instruction, Attorney Sitzberger.
Judge, thank you. And it was the court's comment of sometimes the actual issue is not in the case law, but there's sort of clues to it that made me realize that I did do some research along those lines. There are cases where appellate or Supreme Courts in Wisconsin have very clearly differentiated homicide crimes to that of assisted suicide. One such example I found was State v. Gant, G-A-N-T. That's a 2015 WIAPP 83, specifically in paragraph 13. The general nature is talking about seizing electronics, but very clearly the Court of Appeals differentiates between homicides as a general class and assisted suicide. And so I thought that might be helpful to the court in reaching its decision.
All right, then I know my clerk was able to look at some other jurisdictions, but I want to, before I even mention them, they might not even be cases I can mention. I don't know if they have a similar rule in these states about unpublished and when, and if it can be cited even for persuasive by the heading, it might not be. I know we were looking at some Texas case law, Mississippi case law. Looks like the Supreme Court of Mississippi I believe that's published, so I'll give you that. I haven't read through it yet, but Mississippi versus Williams. 53 Southern, so SO period 3rd, 734, 2010 case.
I'm sorry, can you look at that one more time?
I sure can.
Thank you.
Williams v. State, 53 Southern 3rd, 734 from 2010, the Supreme Court of Mississippi. It looked like one of these suicide pact cases.
Thank you. I'm sorry, one final thought on that, and not that this is controlling to this court at all, but I am familiar with a Milwaukee County case that 3 days ago decided this same issue in a case actually Attorney Cotton was on, where they denied giving the assisted suicide as a lesser included. For whatever persuasive value this court finds in that, it was Judge Wagner in Milwaukee County.
I'm intimately familiar with that case, and this is something to do with a gentleman convicted now of using a rat trap to kill a female friend of his. Is nothing on at the least bit similar to this.
But an assisted suicide jury instruction was requested
Yes,
and not given.
yes, because there was no evidence of assisted suicide in the record.
That's not true. It was because it was found not to be a lesser included offense.
All right, well, I do know that sometimes the statutes or the case law talks about lesser offenses being different than lesser included offenses. So I'm going to look at that as well. I'm just going to take some time to review this since it's 11:26. I'll just break and we'll come back at 2 o'clock for a decision on this, okay?
Thank you.
Thank you.
Did you say 2 o'clock?
2 o'clock, we're in recess.
We'll be back.
Right, I'm eating my dinner, so so we'll stay on. I'll stay on, but what I'll do is I will put something on for us to watch. Better than my sandwich. Yeah, well, this is dinner, not lunch, though, isn't it? So, right, let's have a look. Let's have a gander, shall we? Let me take that off for a second. Let's get something on to get you women all hot and bothered. I know what you like. It's a Friday. And it's Sarah P's birthday. Oi, oi. Let's have a garden day here. Oh, jeez. Trying to do a million things at once here. Hang on. Right, let's watch some chases. We have not watched chases for a while now. So let's watch some chases. Hang on. And then we'll watch some of this till 2 o'clock. It gives me time to eat my dinner as well, and I'll come back on. No worries. Thierry, you got loads of time. You got till 2 o'clock. That's 3, 4, 5, 6, 7, 8 o'clock our time. Plenty of time. All right. But they have financial crime. That's fine, Karen. That's good. That's good. It's good to have your contribution. I haven't looked at the poll yet. Let's put this on and then you can discuss it, guys. But let's watch this as well. For whatever reason, there's no sound. So I'm not sure if Jonathan's. Oh, Jonathan's buggered it. No sound. But you can see it. I'll be back now. Nunia, she's coming back at 2 o'clock Central, 3 o'clock Eastern with the decisions. So I'm just going to play some of this stuff now. I'm just going to wash up. I'll be back now. Here we go. I'm back. What's happening? California. He's going 34, 30. Oh, he's going slow now. Oh, he stopped. Did he stop at the red light as well? I think he's trying to coax that police don't know it's him. Oh no, he's going back up now. Look at him speeding the car now. I mean, where's the police with their motorcycles then? Oh my god, he's stopping at a red light. Oh no, he's turning. I was thinking, is he trying to be now? Look, it's not me. If he had mates at home now, he should phone them and say, hey, I got a copter on my ass here, right? Tell me how I can escape. What do they see? Where can I go? And they could probably guide him to like somewhere. Go, look, they can't see you here. Yeah, I know. But the thing is, he could outrun the helicopter because he could go down somewhere and not outrun this. Sorry, he could hide from the copter if he wants to, but he doesn't know where he can go. Jesus, pick up space now, speed now. Trouble is, it's probably his own. If it was not his bike, he could have dumped it, just walked. Do you know what I mean? But it's probably his bike. That's why he can't dump it anyway. Yeah, but that's what I'm saying about it. Probably is his bike. It must be his bike. Well, it says in the title it's going to do 200 plus miles per hour. Brakes 100 miles per hour. Oh, 100 miles per hour. Is it really 140 miles per hour? Yeah, the bike came out, you idiot. It's there, yeah. Just, yeah. He just needs to go into the tunnel. He's now trying to be like, I'm not breaking any rules. Oh, okay. I'm surprised there. So technically, he could outrun the helicopter then. The view, maybe. I don't know. Look at him stopping there now. He's probably thinking, oh, I'm stuffed. Yeah, I think he's figured out now that the helicopter is there. But I mean, he's buggered because he can't go anywhere. Bicycle's on, but he's buggered. He can't go anywhere. He can't hide anywhere. Oh, the police are behind him. Police are behind him. The police are behind him. Police are sneaking up. Oh my God! There's no need to do that. He put his hands up, you idiot. Oh, that's a bit too much. He put his hands up to go, yeah, okay, I'm done. They pushed him on the bike down. That's ridiculous. That's just ridiculous. That is. Like his hands are up. He's like, yeah, you got me. You got me. Guns are drawn. Okay, you definitely got me. Don't worry about it. Right.
We're now getting a first-hand look at a Georgia car chase turned shootout that left multiple officers injured, one suspect killed, and another with a lifetime prison sentence. It happened on April 12th, 2021 in Carroll County, Georgia, west of Atlanta. That's where a Georgia State Patrol trooper stopped a Nissan Sentra driving more than 100 miles per hour along the interstate. Investigators later determined the driver was Aaron Shelton. His cousin, Pierre Shelton, was in the passenger seat. As dash camera video shows, at first, the driver doesn't stop for the trooper. Eventually, though, the car pulls to the side of the road.
Oh, Jesus, Carol.
But when the trooper gets out to approach the Nissan, it speeds off. Dash camera video shows the initial chase as Aaron Shelton attempts to outrun the trooper. Soon, the trooper gains on Shelton's vehicle. As dash camera video continues, the initial trooper zeroes in on the suspect's car and taps it as it drives along. The car veers out of frame before straightening out once again. Next, Pierre Shelton can be seen from the passenger side of the Nissan pulling out an AK-47. He points the gun back at the Georgia State Trooper and opens fire.
Shots fired, shots fired.
As the chase continues, multiple other units respond to the call, including county sheriff's deputies and local police officers. Dash camera video from other first responders shows them joined together in the search for Shelton and his cousin.
Wearing a yellow hoodie. Floorboard. 6-6, back off of them, back off of them. Back off, let's see what they do. Dispatch, we're right here going 69 miles an hour. I'm waiting to see what we do. We're turning right on Bankhead Highway.
Something highway.
All right, get me some people up here. Let's get ready to do felony stop. If not, we will pit.
Carrollton Police Sergeant Rob Holloway can be heard on body camera video calling out instructions during the chase.
All right, back off just a little. We're going to follow at this distance. Dispatch, we're going 60 miles an hour. Bankhead Highway. We're passing Barnes Store. Get Little Rica set up spikes at Bay Springs.
Couple with some kind of A-frame, something up under it. Definitely an AR stop.
Hey, just make sure we're backed off just enough, okay? I'm going to try to turn on my scene lights. Dispatch, we are going about 90 miles an hour. We are coming up on Old Airport Road.
But only a minute later, shots are fired toward Holloway.
They're hitting their brakes. I'm waiting to see what they're about to do. Chief went back off of them.
229, you got Granby Connor. You ain't got to worry about spikes.
I know, but I don't want to get up here where they're moving around. I'd rather go ahead and disable them.
Sergeant Holloway was shot in the head and crashed his squad car as a result.
Oh my God.
Dash camera video from Holloway's squad car shows the same moments from a different angle.
Oh fuck.
The same moments of Holloway's crash were also captured by another officer's dash camera. As the crime unfolds, video shows officers on the scene take cover, ducking behind parked squad cars. Video then shows some officers move to a new location.
Thank you, Carol. Well, as long as you survive, Jesus.
This
Show
video
the head.
shows the perspective of Carrollton police officer Chase Gordy, who also responded to the scene. Gordy can be seen taking cover in front of his squad car as shots ring out in the distance.
Shit.
Soon, gunshots are fired directly at Gordy. Gordy can be seen calling for help as the gunfire continues. For only 2 seconds, a suspect is seen in front of the squad car, gun in hand. Officer Gordy's body camera video captures these same moments from another perspective.
He's on my car! He's on my car! He's behind my car!
In all, 3 first responders were shot and injured: Gordy, Holloway, and Deputy Jay Repetto. Pierce Shelton also died in the incident. Aaron Shelton was arrested and indicted on 22 counts, including felony murder, felony fleeing, and aggravated assault of law enforcement officers. He was later convicted and sentenced to life in prison without parole. Reporting for Law and Crime Network, I'm Sierra Gillespie.
Jesus. Wow.
Wait, hold on. They coming. I have a mom who's taking a child that I have custody of, and I need help because she's getting ready to get into a car and drive off. I'm in San Pedro. I'm in San Pedro right now.
You have custody of it, like sole custody?
I have sole custody, yes. And she's getting ready to pull off in the vehicle right now. I am at the cruise terminal, Los Angeles.
Hello.
I don't know where this is right now. I'm sorry. There, I don't see an address right now.
Do you have a cross street?
Yes, it's let me see, 1 second. It's Harbor Boulevard is the main street, and Swinford. She's starting the vehicle up right now.
Okay.
And she's revving the engine, and she has them in a car with no car seat. Please. Oh my God.
Son, daughter?
It's a son.
And is she the mother of the child?
Yes.
Black, white, Hispanic, or Asian?
I'm sorry?
Is she black, white, Hispanic, or Asian?
She's black.
How old is she?
I think she's like 38.
What's her name?
Mike Scott. Huh? No, I didn't say that. No, yeah.
And how did she get your son?
It's her son, but she picked him up from Friday. She picked him up from school Friday for me.
And what's your name and phone number?
My phone number?
Yeah. And what's your name?
My name is.
And what kind of vehicle is she in?
She's in a U-Haul Silverado. A U-Haul truck.
And what's the license?
Shit. I can't really see the license right now. I'm trying to make sure she don't leave.
All right, we'll send an officer out.
Calm down. It's okay. It's okay. What's going on?
Don't walk search me like that. I'm in distress.
No, I just didn't want the car to run me.
Please don't call a mental place before you run up on me like that. I'm in distress.
Okay, what's
if you
going on?
need another help for that, don't do that, please. I'm begging y'all. Please don't do that.
Don't do what?
Run up on me and
Look
just
at me.
help.
I'm standing here with my hands in my
Okay.
pockets. All right?
You got that understanding,
Okay.
though, right?
Calm
Y'all on
down.
the page? I'm calm.
No, you're not. Okay,
you
explain
already-
to me what's going on.
I'm calm. I'm calm.
Okay, listen to the officer.
Okay. This officer here?
Yes.
Okay, you know what?
Okay, what's going on?
Okay. So, me and my cousin, okay, here you go right here.
Ma'am, talk to me.
No, it's fine.
Ma'am,
Fine.
talk to me.
Okay, it's fine. It's fine.
I'll tell you what.
Now, we all can talk together since we all here.
So what's going on?
Okay. So, I'm good. I'm a mother.
Okay.
First of all. First.
Yes, I understand. You're a mother.
Okay, and that's it. And I'm having a hard time co-parenting with my cousin here, of course, because then you bring back, you see, it's just me and my child. You know what I'm saying? So please don't.
Ma'am, ma'am.
Okay,
Just making sure
we all can talk. You know what I'm saying? But if y'all wanna do this, y'all can just, you know what I mean?
Listen, dude, I've been able to say about 2 sentences here, okay? Because you haven't been able to explain to me or anything. You keep interrupting me.
I already said I'm in distress already and call somebody that can help me.
Okay, explain to me what that means.
That means that the police does not have no control over this situation.
Okay, I don't even know what the situation is because
Exactly.
you haven't been able to explain anything to me. So why don't you take a deep breath, okay, and let's start from the beginning.
Okay.
All right, because I just got here, and I just got some information from what someone told the dispatcher. I really don't understand. Everyone's safe. I'm not concerned about anything right now. No one's going anywhere. All right, but I need to know why I was brought here. So let me ask you a few questions. This is your son, correct?
Yes, sir.
Okay. And how old is he?
5.
5? Okay. Now, explain to me, before anything happened today, what's the custody situation with your son?
The custody situation with my son was that my cousin take care of my son and protect him by all causes till his mother gets out of jail and able to obtain custody herself.
Okay, so there is a court order that's staying this?
No, there was a court order.
There was
a court order is closed.
Okay,
This
so
is a wrap.
Okay, so tell me what the court order originally said.
The court order said for me to listen to my cousin
Okay.
by all means necessary, because
Your cousin is this gentleman over here, right?
Yeah.
Okay. Okay. So, okay, let me. So you were in jail at some point, correct?
I was incarcerated.
You were incarcerated at some point, all right? And because of that, your cousin had custody of your child.
Yeah.
Yes or no? Okay. So, who made that decision? Was it
Me.
Department of Children? No, who made the decision?
No, I made a decision because I asked the courts,
Okay.
can he go with my cousin? Because I trusted my cousin
Okay.
with all that the court was asking. The court asked me, did I know anybody? That means if I know you, that means a family member, a friend, a neighbor that I might know, a nice police officer from back in the day you might know, anybody in the world that could come get your baby today.
Okay. So the court gave your cousin custody of your child.
No.
No.
No one has custody of my child. My child's in the system, meaning he's up for grabs. If I get in trouble, they're going to take him. If he get in trouble, they're going to take him. So no one's right or wrong here.
Okay.
We don't know
okay,
because
hold on a second.
we haven't seen no judge.
Let's stop that because obviously we're talking in two different languages here.
Okay.
Because
I understand.
Okay.
Because
so
I'm
why don't
upset.
why don't you tell me what happened today?
Oh, what happened today? I got up, I took a shower, I got a shower, and we headed to the park.
Okay.
And then
Let me ask you a question. So is staying with you?
No, the whole time, all
So-
summer,
Okay.
every day that he's supposed to be with him. I take him to school, I fix him clothes, I buy his food. I got beat up.
Okay, you tell me a bunch of stuff that doesn't really
No,
apply, but
I'm just telling you.
No, let me, because I need to figure this out.
Because I'm upset, that's why. So
Yeah,
you keep telling me to calm down. You can't keep. That's why I said, can you call somebody that can negotiate all of our situations so we all leave fair, so no one just cause commotion.
I'm trying to do that.
This is a hazard.
Okay, I'm going to ask you some questions again. Okay, so where do you live?
I live at 14 Nadu.
Okay, is that your own place? Or are you staying with someone else?
No, it's a shared living.
Shared living. What does that mean?
Huh?
Explain to me what that means.
Roommate. That means I don't have enough income
Okay,
to
so
live by
you
myself
have
because
okay.
my cousin gets my income.
So you don't live with your cousin. You
No.
don't live. Okay. Does he live with you?
Yeah.
Okay.
Back and forth.
Back and forth.
Joint custody.
So you have joint custody
Mhm.
with. How does that work out? Is there certain days that you're
Yeah.
supposed to have him and he's supposed to have him?
Yeah, we agreed with him. He made up everything. Like I'm just saying yes because he did me a favor.
Okay.
Let's get an understanding. That's I'm trying to get this understood so y'all don't pick sides.
Is this documented?
Yeah, everything is documented. And that's
So-
why I wanted to have a positive
Do you
conversation.
have a copy of that document?
Listen, I have a copy of certain documents. I don't have all the documents in the world to prove what I'm saying is right. He don't have no documents to saying that he's right. All I did was take the document that the police asked me for.
Okay. Okay. So let's avoid that again. We're talking two different languages, and I don't think we're getting over that. Okay.
But
So
it's not
today,
a game.
so
That's why I'm trying to understand you. No one. It just seems like you don't understand what I'm talking about. He don't understand what I'm talking about. That's why I said don't run up on me like that. To call somebody that can deal with the situation. If you don't know nobody like that, I don't even know who lives in San Pedro. That's why we came to San Pedro.
okay, you're talking about a bunch of stuff that's implied.
Okay, that's what I'm telling you.
Okay.
That's what I'm known
Again,
for.
let me ask you questions, okay? And you can answer them as specific as you can.
We're not going nowhere with this.
Because you're not listening.
I'm
You're not-
listening.
you keep going off on things. Okay. So with you today. Okay. At which point did you first interact with your cousin today that caused this whole commotion happen?
This morning at 6:45.
Okay. What was that about?
Him picking my son up early.
Okay. So he came to your house to where you live and picked up your son earlier than he's supposed to.
Mm.
When is he supposed to pick him up?
At 9:30 p.m. from 14 Native.
So at 9:30 p.m. he's supposed to pick
9:45.
9:45 p.m. today.
Right now.
Okay.
What time is it?
It's like 8:45.
Mm.
Okay, so but he came over at 6 in the morning. All right, and then what happened then? Did he take your son or did?
No, because
Hi, Hannah. We're on break until 9 o'clock your time, European time. No, it's not live, guys. It's not live. It's not live.
that's what I'm trying to get to. That's what I'm trying to get this understanding so y'all don't just ram and kill me or hurt me. You know what I mean? Just going off anybody. Sorry, I've been hurt enough. I just got ambushed in my house on Monday
do you
while
want-
my son was
It's going
there.
to get to the point where I'm not going to listen to you anymore. I'm just going to listen to everything he says
Okay,
because
well,
you're
you
not
already
telling me.
did that. Well, you just,
I haven't.
I already
Well, I
put
just
my
got
point. So that's what you're going to do? We got to go to see
No,
the judge?
you have not explained anything.
I
to
don't
me.
have nothing else to say. I got the right to remain silent if I'm
That's
under
fine.
arrest.
Then do that, okay?
I'm
I'll be right
under
back.
arrest?
No, I just wait there.
Okay, thank you.
What's going on?
So they don't have any documentation
If
on
I
it,
got
so
the
I'm
right
going
to
to call
remain silent, I
DCFS
know
with
my rights.
information they gave me on the child to
Obviously,
see if there's an open case.
everybody knows their
They
rights
said
and
they
they don't give
are
a fuck.
full
Like,
custody,
I give a fuck about
and
my
that,
rights.
she doesn't have custody of him, but they've been letting her see her son because
I
they
don't
said
want to
that
talk
she's
no
been
more.
doing better. So they gave her permission to see him. But today, when they called for her to return the child, she has been kind of evading them, so they had to come here and track her down.
Thank you.
And she's just refusing to get the child. All they want
Oh,
done is
so
to
he,
get
I
the
should
child
have
back.
called kidnapping on here. Okay. Oh, we playing the
So, but
kidnapping
is there?
game.
So they're saying that
my
DCSF
son a
decided
rape
who was
victim.
supposed to. There's no
And
court
he
order
kidnapped
or.
him.
Sergeant, the one that told me, because they don't have an actual they
They
don't
don't
have
have any
documentation paperwork on them.
No, I got it
So
ready. We ran
I just told me to
silent.
just contact DCFS to see if there's an open case on it already, just to verify.
Okay. So, sir, I'm sorry, you have no paperwork, documentation on you at all. They'll help us.
Wasn't
figure this out?
expecting this.
Yeah, I wasn't expecting it. I just don't have it on
I'm
me.
just coming to pick him up as a normal.
Yeah.
Okay. And this is what we're going to do. We're going to take custody of your.
No. So the judge is going to make a final decision on some of the motions, and then tell us in a bit what jury instructions looks like. So they're just taking a break on it, basically. They've gone through it. Judge just has to decide a few things.
Your son.
Yeah.
We're going to go back to the station.
Yeah, and all of us going and wait.
No, your son's going to come with us.
Yeah.
Okay. And then we'll have to figure out what does have DCSF come out, create a whole new case,
Yeah.
start over again.
That's what I'm saying.
Okay. There's no reason.
Agreed. Thank you.
But no. Wait.
Thank you.
Okay.
Yeah.
Or we can. Go ahead and grab him.
I'm just playing. I'm just playing. You didn't give me
We're not
another
playing
option.
games.
Bye. You want your stuff, baby?
Right.
Let him. Can he get his stuff, please?
Okay, you want him to go with him?
No.
Well, give me his stuff.
I'm just playing. Where else he gonna go?
We're not
He lives
playing,
with
ma'am.
him.
Aisha, we're not playing games. Sir.
Okay, we'll get
Okay?
his stuff. Let get his stuff. Like, look, this is very disrespectful.
What's his stuff?
He knows his stuff.
Okay.
All right, just move. He don't have nothing. This man stars my child.
So you know what? If you don't give me his
Okay.
stuff, you can keep it.
No. Well, how am I gonna keep it? And what does that do for my child?
Well, you're not doing anything for your child.
Okay,
right now.
I'm just asking
Okay.
you.
Maisha?
I'm stressed out. I'm
Just
having a hard time.
explain to her what Department of Child Family Services told you.
Okay, come on. You're gonna be good. You can talk.
Okay, don't walk away, ma'am.
I got to smoke. I'm trying to smoke. Okay. Yeah, I'm telling you, I don't blow your face.
I spoke to the supervisor down at the CFS, and they informed me that on 2018 there was no case, and it shows that legal guardian.
2019?
Yes.
No, this been illegally with. See, this is how I know this is negligence. Since 2017. Yeah. So now, what's the next one?
Okay,
That
Maisha.
was the last case that was.
Okay.
So as
Oh,
far
it
as
was
getting
another
prior
one?
Information on it.
Whoa!
You didn't let me finish. Sorry.
I'm just excited. That's it.
So it does show.
Thank you, Sam. Lovely to see you, Sam.
Information that Department of Department of Child Family.
Thank you the other day as well, Sam. You came in and said hello. I explained to people who you were. I said you're an absolute weirdo, and you'd fit in right here. But then you're busy. You could never be here because you're busy with RA. But Sam, 100%, guys. If you think you guys are weird, you've not met Sam. She is a sly bitch, but we love her. So every time you come, Sam, we'll always love to see you. Yeah, enjoy the rest of your day, Sam. But it's always lovely when you pop in. And I wish you pop in more because you'd fit right in with this group of weirdos as well. You'd love Jonathan as well. But thank you, Sam. Love you to bits.
Watch go with help, okay? You know what? We're not gonna do it. Don't worry. Just take him over, walk on the car.
Ma'am.
It's okay. She can.
Does he have a backpack?
Yeah, that's what I'm
Can I grab
saying.
that
All
from
of this stuff.
All right, I'll get that from right?
Damn.
Backpack?
Hey,
Like, why are y'all doing this to me?
We're not. We're just.
Yeah, y'all did. Look.
We're just backpack.
And he told my son that he not safe. Look how he holding my son.
We're just backpack.
I'm your anger. I love you, son. Don't fight. Relax. Y'all have a good night.
You too, man.
This washer.
We are live tomorrow, 11 o'clock Eastern. See you, Sam. 4 o'clock UK time. See you, Sam. See you soon.
So, you guys got all her information?
Yes, my partner has enough.
Okay.
3189.
DCSF know that.
Whoa, hey, hey, hey! 3189.
The incident number is
3189. Whoa, hey, hey, hey! Whoa! 511 officers help. Shots fired. The target. Partner, where are you? Get in the car. Get in the car.
Let DCSF know that.
She's
about
sharing
we
now.
got.
Oh!
Into the curb. Hey guys, any U-turn coming back at the.
Well, when he said shots fired, yeah, the police fired. Why is he shooting at her for? Don't shoot at her, for fuck's sake.
The officers coming back to Kathy off of, I believe it's a Shepherd here.
Oh!
She's gonna go
No.
over the thing there. Oh,
It's actually Councilor Del
Okay,
Mar.
she's out.
TC, into the park here, guys. Hold the frequency control. Hold the frequency up.
Yeah, but point is, I don't think there's a point. She's too far away. But she did well. I mean, the other cop, I can stand the other cop, but that cop was way too far away. Way too far away to shoot.
I can't see it. Airbags are open. We're gonna get her out.
Unit 36 with the vehicle from Del Mar at Kathy.
Yeah, that's my point. Yeah, if we see the copper, the one she ran over, 100%, bam bam. Do you know what I mean? But that guy was like way back. How could they let her drive? But they did. Look, that's where she ended up. Gone.
Go ahead. Approach on this side. So we'll rest from. You guys stand by. Stand by. Stand by. Go ahead. By approach team, go ahead. Stand by. Hey guys, just pull her out and flip her over.
Got it. Got it. Let me know when to approach. Go.
Hey, go ahead. Go ahead. Pull her out. Pull her out.
Give me her. Come here. Come here. On your stomach. On your stomach. On your stomach.
Hold on. Hold on. Hold on. Hold on. Hold on. Anybody else in the front?
Hey, Anthony.
Good.
Good.
Haha, bitch. Right, let's have a look at another one then. Let me have a look at something else then. Hang on. Let's tune something else now then. Here we go. I got something else, something a little bit different now. Something a little bit different. We can back the cars in a bit. We've got something different here.
Let's kick things off in the Benton County Justice Center in Washington State, where a judge has found Gerald Hyde II guilty of methamphetamine possession. With the arraignment now over, he's being taken back to jail. Or is he? The defendant has slipped away from security and re-entered the courtroom. He strips off his prison-issue shirt and uses it to hide his handcuffs. He makes it to the hallway, and after a quick look around, he takes off. Along the way, he ditches the distinctive orange prison-issue shoes and continues barefoot through the courthouse. Quickly makes his way to the lobby until he exits straight through the front doors and out onto the street. All before anyone seemingly even noticed he was missing. But within 2 hours, police catch up with him hiding at a friend's house. He's immediately taken back into custody.
Donut operator.
Next, we head to Jefferson County Circuit Court in Louisville, Kentucky.
We are on the record. Commonwealth versus Rayton Woodford.
Allegation, which is quite
This is 29-year-old Rayton Woodford. He's in the courtroom today for a probation revocation hearing. He'd previously been sentenced to probation for drugs and weapons charges, but violated the terms. Sitting a few feet away is Woodford's girlfriend.
Do you swear or affirm that the testimony you're about to give will be true?
During Woodford's hearing, a detective provides testimony.
That evening, he was charged with a handgun and narcotics.
Okay.
And if you know, was Mr. Woodford at the time a convicted felon?
Yes, he was.
Once the testimony concludes, the camera, controlled by Judge Barry Willett, remains locked on the empty witness chair as the judge announces his decision.
Probation revoked in its entirety. Mr. Woodford, I'm going to send you to serve 5 years. Good luck to you. No, ma'am.
That flash across the screen was Woodford making a run for it. Woodford's girlfriend can be heard pleading with her boyfriend to stop.
The record will reflect that Mr. Woodford made an unsuccessful effort to escape.
Woodford is stopped by deputies. He's brought back into the courtroom now and taken into custody.
Oh, you idiot.
Our next stop is at the Fayette County Justice Center in Fayetteville, Georgia, where 24-year-old Ronard Neal, seen here, appears before Judge Fletcher Sams. Neal's in court today to face previous charges of theft and fleeing officers. But there's one big problem. He was supposed to be there yesterday, but didn't show up. So after a bench warrant was issued for his arrest, Judge Sams orders deputies to take him into custody for failure to appear. But Neal has other ideas. He tumbles into an adjoining courtroom packed with shocked onlookers as he runs through and damages a door. Neal escapes down a stairwell toward the first floor exit. he can almost taste his freedom. But with deputies and police officers in hot pursuit, Neal's returned to court later that day, where he pleads guilty to his previous charges. And for his escape attempt, which included damaging property and injuring officers, Neal's hit with additional charges and 5 more years in prison.
5 more years.
He's currently serving a 10-year sentence in Georgia's Lee State Prison.
Fuck
Go to the
yeah.
Juvenile Justice Center in Nashville, Tennessee. It's after 9 p.m. 4 teens aged 15 to 17 have been left unsupervised while on a work detail, off camera in the basement of the building. As minors, these boys are staying here instead of jail, while they await trial for crimes including armed robbery, auto theft, and murder. And as you can see, they don't plan on sticking around for their trials. They've just come up a basement elevator and are wearing what appear to be yellow security vests. While one of the young men begins making his way down the hall, he changes his mind and follows the others up the stairs. When they get to the ground floor, the teens bolt through the front entrance. No one's stopping them. Cameras catch the entire escape. For now, they've made it and run off into the night. Eventually, all 4 involved in the escape were caught and could now face additional charges. It's later discovered that the 4 teens likely had help from the inside. 2 employees are terminated and arrested for assisting the juveniles in their escape. Thanks for being a fan of Court Cam. Subscribe to A&E to never miss a new video.
Americans, isn't it? Americans. Let's have more American stuff.
The arraignment of 25-year-old Alonzo Perez. He's charged in the murder of Muhammad Robinson. The crime occurred when Perez and a woman stopped at a North Vegas fast food restaurant. After someone failed to hold the door open, words were exchanged, and then Perez allegedly shot the victim dead. The FBI apprehended Perez and handed him over to the North Vegas police for questioning. At 11:57 a.m., Perez is left alone in the interrogation room, handcuffed to a metal bar on the table. Police are supposed to monitor the suspect through a small video camera. As he waits, Perez looks around the room, and it seems the wheels are turning. After nearly 10 minutes, it's clear Perez isn't interested in sticking around. He begins leaning into the cuffs in an effort to snap the steel bracelets. Not likely, right? But somehow, using his own body weight of 200 pounds, he breaks free. Now he must decide his next move. Instead of making a run for it, he remains calm. Watch now, he places his hands as if to disguise the broken cuffs. He even rests his head on the table, perhaps to keep the broken cuffs hidden from the police watching the room. After a few minutes of carefully surveying the space, he knows exactly what he wants to do.
Well, his Dallas Cowboys fan.
Using a step, he pulls himself up to the ceiling and breaks through. Just like that, he's gone, leaving nothing behind but a water bottle, some busted up ceiling insulation, and a soon-to-be embarrassed police unit. Perez makes it to the street, where he then steals a pickup truck, and the murder suspect drives off into the night. It will be another 40 minutes before police even realize Perez is gone. A manhunt begins, as the North Vegas police must admit they failed to properly monitor the suspect. It takes 5 days before authorities finally capture Perez without incident. When they do, police charge him with 2 other previous murders and a separate motel shooting nearly 2 months before his escape. Perez is facing multiple felonies, including murder, felony escape, and grand larceny. If convicted, Perez could be sentenced to death. We head to Universal City, Texas, where police are trying to figure out how did someone cause all this damage to a courthouse in the middle of the night? And more importantly, who caused it?
That's really weird. I can't imagine dispatch seeing somebody come in and just waltzing over here and not, well, these were locked, so they couldn't get in here.
Police investigating the break-in found damaged walls and ceiling debris scattered throughout the courtroom. They also found a strange note near the court computer that read, "I will never give up till justice." Through surveillance footage, police identified this man. 29-year-old Andres Madrigal is a suspect. About a week earlier, Madrigal was arrested on a warrant for a traffic violation and released from the Universal City Jail. As he left, he allegedly told officers, "This isn't over." Madrigal allegedly went to City Hall, where the courthouse is located, and hid in the men's bathroom while waiting for employees to leave for the night. He then allegedly broke through the ceiling and crawled to the empty courthouse area, leaving a trail of damage behind. There, according to police, Madrigal accessed the city's computer system using a password he found under the keyboard. Police identified Madrigal as a suspect, and they found Madrigal's red sneakers, which he was wearing the day of his arrest, as well as a pair of courthouse scissors outside a nearby fire department. A few days later, police arrive at his father's house with a warrant for Madrigal's arrest.
Police! Police department! Police department!
Inside, police search every crawl space and closet in hopes of finding the suspect.
Is somebody on the first floor? Are you dad? Yeah. Where are you going to?
When they come across the suspect's father, he offers his own tip.
She probably jumped out from my window, or the bathroom window.
Okay. The dad said if he's not here, he jumped out the freaking window. He's wearing black shorts, no shirt.
But all the windows are secured.
How you going to the backyard?
Officers then head outside to continue their search.
I'm here.
They poke through fences and scour the neighbors' backyards, but still can't find him. After his father receives a call from the suspect's mother, he suggests his son is probably still in the house.
Yeah, that's right. Hello.
Did you find out?
No, not yet. They're looking for him.
He just text me right now, like, "Mom, help me, Mom, help."
Finally, after 20 minutes, police zero in on an upstairs walk-in closet.
Andreas, come out. Come out with your hands up. Right now. Hands up. Hands up. Hands up. Get on the ground. Get on the ground. On the ground. You're a cop, bro. Stop. You're not even a real cop. I'm the police.
At first, Madrigal says he doesn't believe the officers are who they claim to be.
You're not a real police. I'm here to help you. No, you're not. I am. Relax.
But when he's cuffed, the reality of the situation sets in.
You got anything on you?
On his way to the patrol car, his father has a few words for his son.
I didn't do. What are you talking about?
Madrigal's taken to the police station. He's charged with burglary with intent to commit theft and computer break of a security system. He was released on bond, but the charges were dismissed for insufficient evidence.
For this next story, we want to warn you. The facts are gruesome. But as you will see, daring escapes aren't only attempted in the American legal system. As we head over to Russia. This is 18-year-old Leonid Grazer, who's on trial in Moscow, Russia, for the murder of his sister, Aradia Koral. According to the defendant, he was commanded by Satan to kill his 21-year-old sister, who he stabbed multiple times. Today, Grazer's in the Sherbinsky courthouse behind the walls of a glass cage. This practice is rarely seen today outside of Russia to prevent dangerous criminals from attacking or possibly even escaping, which is exactly what Grazer's planning to do. It appears now that Grazer's calmed down. But moments later, he somehow has slipped through the slats at the top of the bulletproof security dock. A gap in the video doesn't reveal how he did it, but if we look again, officers consider opening the box to stop him, but Grazer's way ahead of them. One officer strikes him, but he's not giving up. The female officer runs over and presses a large button on the wall, calling for backup. Grazer's pants are coming off during the escape. The officer has a firm grip on Grazer's leg and is not about to let go. Then another officer arrives. At this point, these Russian officers are not playing around. As the taser comes out, he makes sure Grazer knows what's about to happen. Grazer's finally had enough. After putting his pants back on, Grazer will go on to make a full confession for the murder and said he had no regrets about what he did.
Wow.
Dayton, Ohio, where a camera keeps watch of a female holding area inside the Montgomery County Jail. Most inmates are here awaiting their first court appearance, including Jessica Boomershine. The 42-year-old was charged with multiple violent crimes, including kidnapping, felonious assault, and aggravated robbery after she and another person allegedly assaulted and robbed an elderly man inside his home. At first, it looks like Boomershine might be napping with her head resting against the screen of a video monitor. But seconds later, she appears to be up to something. As she stands on an attached stool, the other inmates barely pay her any attention. But after she slides a chair over and climbs on top of the video monitor, she catches the attention of these two inmates, who are completely confused. Then it appears the inmates realize what's going on. Boomershine is trying to skip her court appearance by escaping through the ceiling. The Mission Impossible style escape gets the inmate in this holding cell very excited, though it's unclear whether she's trying to get the guards' attention or is actually cheering on the jailbreak. Either way, the commotion brings officers into the holding area just in time. Ceiling tiles begin raining down from above. Another security camera pans to the right, catching an even better view of Boomershine hanging from a ceiling vent. And below, an officer's attempt at trying to grab her legs makes the situation even more awkward. Boomershine really doesn't want to go to court today, but ultimately the ceiling gives way. She crashes headfirst into a trash can below. Once on the ground, officers place her in handcuffs before she's checked out by medical personnel. Boomershine sustained only minor injuries from the fall, and though her botched getaway allowed her to skip a court appearance that day, escape and vandalism charges were added to her case for when she eventually appeared before a judge. We go to the Juvenile Justice Center in Nashville, Tennessee. It's after 9 p.m. 4 teens aged 15 to 17 have been left unsupervised while on a work detail off camera in the basement of the building. As minors, we go back just 2 years earlier. These staff members have been tracking a teen as he makes his way through the ceiling, just a few feet above their heads. Though he's just out of reach, the ceiling begins to give way. The ceiling doesn't hold, and the defendant crashes through. Security's not giving up and immediately surround him, as his daring, though poorly planned escape comes to an end. Watch again as the juvenile makes one last effort to flee. Security's taking no chances of letting him escape again. He's unhurt and immediately taken back into custody. After this incident and the most recent escape, the city of Nashville is considering taking over operations of the privately run center.
Thanks for being a fan of Court Cam.
Hey, hey, hey. Hey, hey, hey. Hey, hey, hey. Hey, hey, hey. I've seen this one before. Oh, 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 oh. Oh, 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 oh.
Next, we head to Jackson, Michigan for a sentencing. Judge John McBain presiding. 18-year-old Damian Hopkins has pled guilty to first-degree arson. 5 months earlier, Hopkins set fire to the home of Charles Penn, the father of Hopkins' underage girlfriend, Alexis Penn. Hopkins claimed he was protecting Alexis from an abusive father. The house was completely destroyed, and Charles suffered first and second-degree burns. Alexis's older sister was in the house the day of the blaze, but was unharmed. Both Hopkins and Alexis were charged with starting the fire. Charles, meanwhile, has never been charged with abusing his daughter. Hopkins pled guilty to the arson charge in exchange for having a lying to a peace officer charge dropped from his case. The state's suggested sentencing guidelines are 15 to 30 years in prison. Today, Hopkins' attorney Susan Denke asked the court to consider her client's positive impact on the community.
Hello, hello, hello. Mother Hubbards. Damn! Damn! A&E. Damn! You buggers. Right, let's have a look here. Where are we now? Oh, this is a nightmare. Okay, that's okay then. Okay, that's all right. Right, let's go back to something we can actually watch then, because obviously can't watch that anymore. Everybody, yeah, rock your body, yeah, rock your body, why? Da, da, da. All right. I've got to be careful what I choose, you know. Oh, Right, I got one here. Hang on. This is fine because it's baby when the night goes on, baby when we do it, when the night goes on. Here we go. I got my caught it. Got a mic here now. My new mic, baby. Hey, hey. All right, let me put it back down. All right then. Press share screen. Not yet. Yes. Do not worry. I got court ready. I got a court right up. It's open. So once they come back to court, we'll go back. Nunya, worrying. Great, worrying. No, it doesn't make a difference. It doesn't make a difference. I've done that before, and it doesn't make a difference. You can stop as much as you want. They still claim it. And it's just not worth it anyway. Oops. It's just not worth it anyway. Present, share screen. Hang on.
Away from downtown. 46. Take it left. Shots fired! Shots fired! Shots fired, Lane! Shots fired! I'm in the traffic in the opposite lane. Crossing back over. Headed toward downtown. Lake, Eagle 1, be quiet. Hold on. Lake, shots fired. He shot fired. Shot at me again by the cemetery. That's the meeting now. Holding the traffic about behind the cemetery. He was shooting at me in front of the cemetery. We're still southbound coming up towards downtown Mount Dora. It's a white male, looked like a black handgun. Copy, shots fired.
Please say a command.
Shots fired, shots fired. Thanks, every EMS in route, shots fired. Stand by. 10-4. What's your call fired? Shots fired, shots fired.
Try saying the device name like phone or use speed. Main menu. Say command.
Crash is fine. He's out on the ground. He's out on the ground. Hands on his head. Hold it.
What the fuck? Yeah, with those, Katie, I just cover the logos.
Recording.
(344) 315. Lot 2369. Let me check a Wyoming temp tag. Again, Wyoming temp 344-315.
Go ahead.
And put back on a black 2019 Volkswagen Jetta 12 last through July 18th.
Kevin, do we have any context with that name?
Let's go grab a quick coffee. Be back now. Need some coffee.
Following it westbound on 2nd from Wyoming. Driving very slow. A little bit of touching the outside lines. Is that something we want to stop?
Yeah, go ahead, stop it. I don't know that we're filling stop level, but get a couple of cars on it. Can't see where it is.
Currently westbound 2nd, coming up to Sun. Anybody in the area we can try for 2nd and Country Club or somewhere further west.
I'm coming by 2nd and McKinley.
Low on 369 traffic stop. Myself on 368. We'll have a stop on that black vehicle. Will be 2nd and Bev. Now 33, 34. .369 vehicles fleeing westbound. Permission to pursue. Westbound 2nd through Elk. Vehicle ran the red light. Speeds 80 miles an hour. Passing WMC.
369 we're continuing westbound on 2nd Street. You're going to be coming up to probably Lincoln. These are about 80.
369 vehicles still running west through McKinley. Vehicles through Kimball into the downtown area, not stopping. Hold the air. Vehicle crash, vehicle crash, vehicle crash. Stand by, I'll get you location. .369 vehicle crashed at Durban. Trying to find the car.
Set up a perimeter.
Hold the air. Roll over. Walcott right now.
They were approaching the front corner road. Looks like we're probably going to go by it other side. Okay, we're passing front corner road, westbound, speed 74 miles per hour. Traffic is still light. Mile marker 21.4, speed is 72. We're approaching Reed Road. It's about a mile out. Yeah, how many crews are involved in this now? Sorry, my car myself, 3 source. Two low profiles, one unmarked. There is no
So most cruisers engaged in this. Stay in the area, please. We're in the center lane. They Silver Dodge. Okay, we just passed you, George. 74 miles per hour. Still in the center lane. OG 55 is southbound on 20 or Freetown right now. I'm going to try and get to the Bragg. I have fingers on board. Westbound, we're a half mile to the 24 extension southbound. Okay, mile marker 14, looks like we're going to pass the 24 extension. Still westbound, speed is 72. Okay, Somerset CDS from the other route, looks good.
Yeah.
So we're in the middle lane.
Yeah.
Okay, all cruise them Somerset. This traffic is going to be out there with 6. Okay, the Silver Dodge SUV. We're in the left lane now. You'll pass this limit. They'll be approaching the tunnel.
So are all cop cars automatics then? Are they all automatic cars? We're not used to automatic driven cars in the UK.
You're back in the middle lane. Speed is 75. Okay, we're in the right lane now. We're entering the tunnel. Okay, just past 79. We're going to be getting on the Bragg Bridge. Back in the middle lane. Speed is 65. Traffic still light. Middle lane, Bragg Bridge. Just have a circle pull up out there. Caution, please. Okay, we just had the Somerset. We're going to be getting off the Bragg Bridge in a few seconds. Middle lane, 70 miles per hour. We are 1 mile out to Route 103 from Somerset. 1 mile out, 103. Middle lane, 70. Half mile to 103. Middle lane. You guys see Somerset up ahead. Middle lane, we're going to be passing 103. Okay, we see. I'm not sure if this is a GPS signal now. Okay, we just passed 103. Middle lane, 75. 1009K, I'm right behind you. If she doesn't bail, don't chase. I have the dog. Yeah, it's not join this pursuit because I'm the cat. This is 175 middle lane. The K9 crews are all loud. Break off once you get up here. Okay, receive. Yeah, we receive that. We're finally hoping to keep up. Okay, we got 9 miles to the state line. We are in Swansea. No middle lane, 75. 1009K, the duty officer, number 2. Okay, receive. 1455 and 6 west right now. I'm going to jump up to 136 to get out of it. We're mile marker 8.2, westbound, 73 miles per hour, middle lane. Traffic still light. 1871. I'm going to hop in the body in case you bail. Legally. The 1009 is going to be the lead. I'll be secondary behind him. Proceed. We just entered Swansea, 75, middle lane. The K9 crews are all loud. Break off once you get up there. Okay, we're on the line with Visine right now. Yeah, we received that. We're calling ahead to Swansea, Visine. We got 9 miles to the state line. We're in Swansea. Still middle lane, 75. I don't know what's going on. 1455 and 6 west right now. I'm going to jump up to 136 and get ahead of it. We're mile marker 8.2, westbound, 73 miles per hour, middle lane. Traffic still light. Middle lane, 73 miles per hour, traffic still light. Up, change to the left lane. Half mile from the rest area in Swansea. Okay, reaching the 1009 is going to be the lead. I'll be secondary behind him. 1455, you can still make it. I'm at 136 now, just trying to get through traffic. We're on the line with Visine right now. Just past the west area. Okay, passing mile marker 7.4, just past the exit. Back in the middle lane. You're in the right lane. Half mile to Route 136. We're going around 2 please now. 873 right lane, approaching 136. 1455 getting on to 136. Mile marker 6.6. Middle lane, 73 miles per hour, traffic still light. Up, change to the left lane. Half mile from the rest area to Swansea. Here it is. 1455, do you think you'll make it? 1455. I'm at 136 now, just trying to get through traffic. Rehoboth, speed is 74, middle lane, light traffic. Okay, we have 1 mile to Route 136, just past the rest area. 75, traffic light, they are no left lane. Back in the middle lane. Okay, we're in the right lane. Half mile to Route 136. mile marker 3.6, left lane. 73, right lane, approach 136. Okay, just keep your pictures on this. 1455 is on from 136 right now. I'm going to shoot up to the way station. Okay, middle lane, speed is 75, mile marker 3. Middle lane. Okay, see 1455, we're middle lane. Coming up on you. Okay, 1455 is pulling ahead of us. We are entering Rehoboth, speed is 74, middle lane, light traffic. I'm going to set up at the way station exit. Just give them some distance, let me know what land on. Looks like successfully. Now 25. Alright, we have sequence on the line. Keep going this distance actively so we can inform sequence with it. Mile marker 3.6, left lane. 1455 is about a half mile ahead of us. Okay, just keep the sixes on with 75. Mile marker 3.2. Okay, middle lane, speed is 75, mile marker 3. Middle lane. All 4 tires are still intact. Okay, I see you 1455 with middle lane. Coming up on you. You're back in the left lane. Left lane. You're back in the left lane. Left lane. I'm not the one posting Alpha. Left lane. Left lane. Okay, 6 was deployed, looks like successfully. Now 25. Thanks. Now 25. We are approaching the line though. Okay, received. Okay, on the 2 right and front left, looks like she's pulling over. Mile mark is 0.2, she's pulling over in the breakdown lane. Okay, see that, we will not follow out of state. Mile marker 1.4, speed is 75. Mile marker 1, approaching 114 Alpha. Sequence and set up with 6. Sequence and set up with 6. Middle lane, just past exit 1. Econ has eyes on you. Okay, it looks like they hit the sticks. Unknown if it's going to take effect. We are approaching the line though. Okay, you see.
Positive hit on the 2 right and front and left. Looks like she's pulling over.
Mile marker 0.2. She's pulling over in the breakdown lane. Received.
Hey, 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 goodbye.
All right, looks like he's pulling over here just south of Stevens on Gratiot. Waiting for me to get out. Ready? It's probably going to take off. Windows
Yeah.
down.
Windows down. Windows down.
He's taking off. Copy, taking off. Charlie 2-1's primary will be calling it. Middle lane, continuing southbound on Gratiot. Alright, looks like he just banged his shot here on Charlotte.
Westbound.
Westbound 94. Notified Detroit Interstate, please. Wind down.
All right, one's bailing, two's bailing, 2 black males, 3 black males in hoodies.
Kelly.
Northbound Kelly.
Northbound Kelly.
David 50 dispatcher, start the track for 18505 Kelly.
He right here. He right here.
No idea, right? That's it. That's it.
Sam, William, David, Sam, Red Chrysler. Northbound coming in to Rogers. Let Rogers know. Let Benko know.
10-4. Sure, back on a red Chrysler 300. Able for Rogers confirmed.
He can shoot, not take 85. Let Benko know. See if there's anybody that can help.
37 and 35 or 1019 from 78.
So we're running about 130 now. Okay, looks like we're going to be taking 87. Never mind, he's going to continue straight here too.
7, I'm on radio.
We're coming up on the 88. Traffic is still beating up roadways. Clear and dry.
36, will you chase them for me?
101. 7, if we get up towards Missouri, I'm going to put him out. You know, this traffic.
And what's your traffic like right now?
It's medium, but I don't have, well, medium to light. There's no good areas out here. He's blacked out. We're running about 110, 120.
Yeah, be careful. And if you get an opportunity when the traffic is clear, try to pit.
Same for everything up here is more of a drop off. I'll wait till we get out past 93.
I think that's a good idea.
He's doing about 106 now, so he's slowing down a little bit, and he did turn his lights back on. We are back up to about 120. Taking the 93. Just kidding, we're not taking the 93 anymore.
Is that traffic lightening up, eh?
10-4, we're just not past the 93.
37 and 35 are past 88 now.
Looks like he's trying to run from Missouri.
What's your speed now?
110.
Yeah, 4 copy 110, and is traffic still lightening up?
Keeps brake checking me every time I try to go into a pit. Looks like we're gonna try to stop. Now we're rolling about 37 on the shoulder.
Think you can try to pit at that speed?
10-4, he stopped brake checking me. Tried, I cut it a little short. Driver, get out of the vehicle! Driver, get out of the vehicle! Driver, out of the vehicle! Hands out! Hands where I can see them! Both hands! Roll the window all the way down! Roll the window all the way down! Now open the door from the outside! Open the door from the outside! Both hands out the window! Open the door from the outside! Outside! Stand up! Let me see your hands. Turn around. Turn around. Turn around. Back up. Back up. Get on your knees.
36, y'all still rolling on the shoulder.
Negative. I got him. On your knees. Put your hands over your head. Is anybody else in the vehicle? Why are we running, bud? You kept brake checking me. 36 on 215. What do you got in there, bud?
In the car? Where?
What do you got in your car?
Nothing.
Nothing? So why are we running?
I don't know. I got scared. I don't know.
You got scared. You just turned a traffic ticket into a felony, bud.
Hey, hey,
How do you westbound now on Holly? And to turn around?
Westbound on Holly down. You have been advised.
Red, blue jeans, behind the target.
Personnel for the blue jeans behind the target. And I'm over here.
Get down, right now! Get on the ground! Get on the ground!
Yep, got it.
You got a gun on you? No, sir. Got anything else?
That was too boring. We got a little bit of time. Little bit of time until we begin. Yeah, 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 yeah. Oh, dee, 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 dee. Da-da. Louisiana. No, I don't want that again. Because I'm crazy. Crazy. Baby, please. I'm just trying to look for something. Can't find anything yet. That would be okay for us to watch. Bam, 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 bam. Bam, 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 bam. Dee, 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 dee. Dee, 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 dee. Dee, 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 dee. Oh. Do you know what? I can't be asked to play it anymore. You and me were meant to be. You and me were meant to be. We will see. We will see. I thought I'd entertain you instead. Yeah, yeah. Here we go. I'll entertain you. Let me entertain you. Robbie, let me entertain you. Do, 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 do. It's Sarah P's birthday today. I hope you all wish Sarah P a happy birthday. Happy, happy birthday, Sarah. Happy birthday. I hope the husband of yours, the kids, have bought you something nice. Feet up tonight. Literally, feet up tonight. Sarah, go enjoy yourself. Let yourself go, Sarah. Bam, 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 bam. Whoa. Whoa. There we are. Let me tell you, let me make you smile. What do we have though? You're the one that I want. You are the one I want. Ooh, ooh, ooh. Hey, the one I want. You are the one I want. Ooh, ooh, ooh. The one I need. Oh, my voice is doing. Oh, yes, indeed. My voice ain't back. My voice ain't back. Duh. You see? Duh. Duh, duh. I'm definitely not cooking dinner, but we can't go out because it's an Aggies home game weekend. There'll be a million extra people in town. We'll just get takeout and chill. The kids, you and husband, take out and chill and then you could put your feet up in the air later on tonight then, before you go to sleep. That's why you gave present for the husband. Yay! It's a bonk day. Ba, 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 ba. I don't want leftovers. Oh, we haven't seen hens today. Jonathan got it. I haven't seen hens or Danny today. I hope they're okay. Especially, Sloppy Joe's a bust. That's what she said. Oi, 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 oi. Also, home game tomorrow, Texas A&M. That's a bit of a nightmare. I didn't realise how far out the way College Station was. It's so out of the way, and it's like it's a cult country, isn't it? They call it cult country. Oh, sounds court's got something moving. Also, Corey, the audio setup has zero noise or clipping, static sounding, etc. It sounds so clean and smooth on my sound system, on your sound system. Well, I need to listen back to it. But you said it was echoey though, Jonathan. So I need to sort the echo out though, don't I? I don't want it to be like a empty room sound. Old Mike hissed a bit too. Old Mike was bloody 4 times more expensive. It's awful. We have too many people in town already when the Stevens are here. Then you add all of their friends and family, and no one knows where they're going. We just stay home on game days. Not worth it. No, I don't blame you. Don't blame you. Do not blame you at all. What made you go to College Station? Like, what? How random is that? Why College Station? Over everywhere in the world, you went to College Station. There must be a reason for it, Sarah. We have quilters from all over the world here for a week in April. It is complete hell. I have it. I think it was Erin Hackler was having trouble getting the kids to eat them. She was on cooking. Yeah, Sloppy Joe's. The kids will not eat takeaways secondhand. I love secondhand takeaways. I think sometimes it's nicer the second time around than it is the first time around. I always eat takeaway. Sarah, I'm in a college town too. It has its perks and drawbacks. Game days can be a pain. It does. Well, it sounds like Katie. Remember, my dad got a job here when I was in high school. Oh, not high school. Especially when you're 5'4". No, okay, that makes sense. So you've lived there all your life. Well, most of your life. As in, since you were in high school. Fine. That makes more sense. You didn't actually move there for a job or anything. You moved there because your father got a job. That makes sense. That makes sense. More than sense. But yeah, I'm surprised you didn't go to Texas A&M, Sarah. If that's the case, go to Texas A&M, become a cult hero. Sarah P. 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 She's a cult. She's a cult. Sarah P. She's a cult. Sarah P. She's a cult. Sarah P. She's a cult. Katie, we have grown so much so fast that our roads don't really support the amount of traffic we have. When they're here, good for the local economy, but it's so great then. But it's so great when they will leave. I went from the sticks literally to Murfreesboro. Tennessee, talk about shocking the system. I hated it. Don't really like living in a city. Yes, when the students leave its lives, it is like a big cult here along. See, so Katie and Sarah P, they live in a cult. We want Octopus for the well, Jonathan. A mouse would call it a city. Nunya naked. Nunya loves being naked. Oh, Sarah P, that would definitely be a culture shock. Jonathan, I need to work my car a little bit this afternoon. Well, there's not going to be much left here, Jonathan, today, to be fair. I am super tired, by the way, so it's catch up with me. There's not going to be much left. She's just got to agree on everything. You can have all the octopus you want. You can have all the octopus you want. You can have all the octopus, have all the octopus, have all the octopus you want, Jonathan. Singing aye aye yippee aye, singing aye aye yippee aye. You can have all the octopus, have all the octopus, have all the octopus you want, Jonathan. Well, officially, I'm also. I don't remember what I sang now. I don't remember. I change them all the time. I don't remember none yet. What I sang for you. Also, my throat is going again. It's a bit crackly. Ba, ba, ba. Much longer lunch. Just try. She's out for another 12 minutes. Well, if they take the whole 12 minutes. Court did move, but no judge yet. Have to pay me $1 million to seat. $1 million. You're quite a cheap date there. Nunez a cheap date. $1 million, geez, and the rest. Can you believe the award amount? How much did she get? Something like 52 million, wasn't it? Was it 52? She was awarded 2 million, and I believe wasn't it 50 afterwards? It makes it 52. No, because I think they each got like 2.4, 2.5 million each, didn't they? 41,000, that's 10. Okay. Not sure. Yeah, I think it was 52 million, but it could well be more than that. I have no idea. I always picture those videos of people trying to eat like octopus and trying to crawl out of their mouth. Oh, yuck, yuck, yuck. Yuck, yuck. Right, they should be back in a little bit. We're surprised. I was saying it would take more than $1 million for me to eat octopus. None yet. More than $1 million. The family got to screen. Oh, okay. They're never going to get that money. Never going to get that money. It's now goes through another process, isn't it? You know, they're going to get maybe 20 mil, 20, 30 mil of that, if that. I always picture these pictures. Oh, no, don't. Yes, law me too. I don't really care what I'm allowed to do. Holy crap. I'd be surprised if they see a quarter of that. Yeah, 100%. Be surprised if they see a quarter of it. Why is that, Sarah? I saw a video recently when one got stuck trying to crawl out. Oh, no, don't. Be just surprised if the hospital system can afford to pay out. Yeah. He was jury awarded. Experience handling civil, I've experienced handling civil liability. Jury awarded. It's now it goes to the next stage. About how to pay it and stuff like that. So the jury recommended that much, and then whatever the next process is, I don't remember. Yeah, they're never going to get 261 million. Never in a million years. They will deal out of court because the hospital is just going to drag it for years upon years. Yeah, like Nunez says, they're just going to drag it. There'll be so many obstacles. So many obstacles in my way. Corpse, maybe. Yeah, they're probably caps. They're probably caps, but yeah, they'll take a deal. They'll take a deal. You know, if they were offered 50 million, they probably should take it. You know, but I don't know. I'm sure they were close to limits. Yes, excess layer insurers will fight. Yes. Not for compensatory damages. Close and followed by close, whatever it takes. Yeah, I mean, they won't pay it. Suicidal without compensatory, I have many years of experience. I'm sure, Katie, I'm sure. Not dismissed it, I just can't see them paying it. Cannot see them paying anywhere near that amount. Near it. They will appeal, they will go bankrupt, they will do everything they can. I agree. Bam, bam. Right, we got 7 minutes. Your husband works in the area. There you go. I don't know. We'll just see. We'll just see. You know. The main thing is that they won. Insurers will pay it. Yeah, I don't know. I don't see them paying 261 million. I don't see it. I think the insurers would fight that as well. 261 million. Anyway, I don't know. I don't know enough about it. I'll be surprised if they do get 261 million. But hey, I don't know enough about it. So I think 50, 40, 50, 60 would be a reasonable amount. But I don't know. What do they have to lose at this point after being awarded that amount to pay? Nothing. They have to be sure to that level. Do they? I never gonna pretend that I gave a damn. Everyone's offended, come get it. We throw in hands. Anybody not trying to make America great again? You pawn, you a clown. Better know where it's that. Jonathan, where the fuck is that coming from? Where's that coming from? No one said anything. I'm not sure I'll make it for a court to start up again. No worries, Terry. Hopefully there won't be much here anyway. Hopefully she'll make her rulings. I'll be like half an hour done. Hopefully, we'll see. Wouldn't that mean some limit if insurers pay it? I don't know. What do you mean in the air? Lol, I'm listening to music. Okay. Okay. The hospital's nothing to lose. Yes, well, they just go bankrupt, don't they? Everybody loses their jobs and we're a hospital down. Well, you're a hospital down, I imagine. No, I clicked that by accident. Oh. Right, there's that. Yeah, I'm surprised everyone here is red, you know? Everyone's redhead. Things must be different in America because I can tell you now, if this was the UK, the insurance providers would not be paying. That's for sure. Do, 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 do. This mic better be good now, Jonathan. I've not listened to it. Oh, I might listen to it a little bit here once I've got a little bit of a break here. And listen to it a little bit here once I've got a little bit of a break here. And listen to it a little bit here. Bye, Nick. Catch you later. No, of course not over. We're waiting for court. We're doing it. Mike. We're waiting for court, Mike. We're waiting for court. It's starting back up in 2 minutes, Mike. Ba-da-ba-da-ba-ba. Hey, it doesn't sound normal, Jonathan. It sounds like I'm in an empty room, Jonathan. But I thought it sounds the same as the other mic. But I don't listen to the other mic, so I can't judge that. But it sounds like I'm in like the bottom of an ocean, like in a room, in a box. So I need to get something sort that out, don't I? All right, come on, Judge. Let's get you back on here. Let's get you, Judge. Doesn't sound empty on my TV. Does it not? It generally sounds empty on mine. Maybe it's because of my phone. This might be good now, Jonathan. I don't listen to it. Oh, I might listen to it a little bit here. Once I've got a little bit of a break here. Could you hear that? That sounded like empty. Might be because of my phone. I don't know, but it might be fine on laptop. But on my phone, it sounded like distant. Jonathan's pissed now. He's like, "Oh, motherfucker!" Ba 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 ba. Jonathan's added a category cars and motors in Discord. Jesus. You better watch out. You better watch me. You better bump on, I'm telling you what. Santa Claus is coming to town. Santa Claus is coming to town. Ba-da-da-da-da. To town. Dee 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 dee. Dee 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 dee. Dee 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 dee. Dee 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 dee. When Huey once telling you twice. Do do do. Something nice. Beady, beady, beady. Shrap is too early. No, it's not. Thank you. And my kids started playing Christmas music last week, and I was like, no, Mom, not yet. Naughty or nice, yeah. I love Christmas. I love Christmas music. 1 year, Jesus. Hey, Jonathan, mine, I'm listening to it. Mine's echoey. Mine's in a in a room. The mic. So I'm not sure. I need something for that tonight to sort it out. Watch out, none is about. If you're ever about, watch none is about. Bouncing naked in her condo. Nunya loves it now. Do 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 do. Para para pa pa pa. Para para pa pa pa. Para pa pa pa. Dee 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 dee. Dee 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 dee. Do 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 do. Do 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 do. Bara bara ba ba ba. Dara bara ba ba ba. Bara bara ba ba. Dee 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 dee. Dee 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 dee. Shoo doo 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 doo. Doo 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 doo. Doo doo doo. Boop boop doop. Nunez a boop doop. Ba 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 boop doop. Nunez a boop doop. Boo boo. Boo 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 boo. The rest of the day you're sitting in the car. That's a big. Okay, my lovely YouTube family. My boss has given me the rest of the day off. I listen in my car. Thanks for being here today, everyone. Welcome, Mike. I'll see you all next week. We're going to be out. See you, Sarah P. See you, Sarah P. Nice of you to have a day off. That's there. Some of us 6 days a week. We go for it. We go for it. We'll see you Monday. I'm not sure what we're doing Monday. We'll have some sort of stream, but I don't know what yet. To be our first Christmas report. Oh, did he send you home because your birthday, innit? That's nice of him or her. Listening. You better be listening. Just kidding, be safe. Love you all good for you, Sarah. Enjoy yourself. Sarah, enjoy your birthday, you said. Sarah, enjoy your birthday. Sarah, enjoy your birthday.
For example, sub 1.
Oh shit! Do you know what I did? I put it back to the start. Oops, my bad. Oh, it's only 5 minutes. We're behind. That's good. So court is here. I must have pressed something. My bad. We are here. Court is back. Here she is. Checking it twice.
All right, we are back on the record in State versus Jessy Kurczewski, case number 21 CF 885. Appearances, please.
Randy Sitzberger, Abby Nicolai, and JJ Crawford for the state. Good afternoon.
Donna Kukler and Pablo Galaviz are here with Ms. Kurczewski. Good afternoon.
Good afternoon to everyone. We are back on the record so that the court can give the decision on the request to include assisted suicide as a lesser included offense. I've had an opportunity to look again at the jury instruction for assisted suicide. I reviewed the instruction for first degree intentional homicide. I reviewed the special materials to the jury instructions in Wisconsin, specifically special material 6, which is all about lesser included offenses. I've read through the statute, which is 939.66. Although I had referenced some out-of-state cases, and while I did look at the Mississippi case, I didn't really go much beyond that. Wisconsin has a very specific statute when it comes to lesser included. Clearly, Mississippi allows instructing a jury on lesser non-included offenses under certain circumstances. Frankly, I think our homicide section of the lesser included statute is a similar type of mechanism where it's special circumstances where it's not so important that we look at the elements test, but they're still different from my perspective. So I read it. I thought it was interesting, but doesn't really have a whole lot of persuasive value on anything that I'm doing here today. I re-reviewed the motion from the defense, and of course, I considered the arguments that were made by the parties. So I briefly became aware that there may be a late filing related to this. I have not had an opportunity to review it, and I'm not going to take the time at the moment. I believe both parties had a full opportunity to present whatever arguments they wanted at the time, and that will simply be there for potential appellate purposes. So I want to start with the statute because obviously that's the first place this court needs to look, and that's 939.66. Sub 1 would be one particular well, let me back up. The statute says that the court has authority to include an instruction on lesser included offenses under certain circumstances. From my perspective, after reviewing that statute, I believe this court need only look at sub 2. And part of that is the other provisions, the other subsections are not applicable in this case. For example, sub 1, which talks about a crime which does not require proof of any fact in addition to those which must be proved for the crime charge, and of course, one which would have a lesser penalty would be a lesser included. The crimes of assisted suicide and first degree intentional homicide have very different elements. And when you look at, for example, the assisted suicide, you have to, if it's a crime that's being charged, the elements would include, and facts and evidence would include that not only that the deceased committed suicide, but that the defendant assisted in committing suicide, and that the defendant gave assistance to the deceased with intent that the deceased take his or her own life. From an element standpoint, though, element 1 is not something that's included in intentional homicide. So I think that's important to note why sub 1 of 939.66 is not applicable. But I also took a look at sub 3, because that allows the court to instruct on a lesser included in the context of this case where a homicide is charged, or perhaps the crime is not, I'll just read it. A crime which is the same as the crime charged, except that it requires recklessness or negligence, while the crime charge requires a criminal intent. And obviously both assisted suicide and first degree intentional homicide are intentional offenses. And so that subsection isn't applicable either. So I focused on 939.66 sub 2. And as the parties are aware, this court has to consider a two-step analysis when reviewing and deciding a request to include a crime as a lesser included in the jury instructions, and so instruct the jury. The first issue this court has to address is assisted suicide a lesser included offense of first degree intentional homicide? And then secondly, is there a reasonable basis in the evidence for a jury to acquit on the greater offense and convict on the lesser offense? As we know, some courts have overlooked or said we don't need to address the first question because they answer the second question in the negative. But I think it's important in this particular case to look at both of these questions. And so the first question that I looked at is assisted suicide a homicide? And it's really important that the language of the statute be followed. And so when you look at 939.66 sub 2, it says this, and I'll preface it by saying the very first part, so above sub 1, sub 2, etc., says, upon prosecution for a crime, the actor may be convicted of either the crime charged or an included crime, but not both. An included crime may be any of the following. Sub 2, a crime which is a less serious type of criminal homicide under subchapter 1 of chapter 940 than the one charged. And I believe another way of asking this question is assisted suicide a homicide? And for reasons that I will explain, I believe, and we'll so find here today, that it is not. First of all, when looking at the plain language of the statute, the statute could have read, instead of a crime which is a less serious type of criminal homicide under subchapter 1, if it had said a crime which is a less serious crime under subchapter 1 of chapter 940 than the one charged, the inquiry would stop and the answer would have to be, yes, it's a lesser included, but that's not what the statute says. And I need to give meaning to the entire verbiage of sub 2. So when looking at all of 940 and specifically subchapter 1, I noted that, and I think it's kind of a clue, if you will, to the legislative not intent, but the meaning of the statute itself is that 940.01, 940.02, 940.03, 940.05, 940.06, 940.07, 940.08, 940.09, and 940.10 all have the word homicide, except that one has the word murder. There are other offenses listed, including mutilating a corpse, assisted suicide. We have abortion exception, partial birth abortion, all under there. And I am by no means getting into a discussion about whether any of those things are a homicide or not, other than to note that the definition, if you go all the way to 939, and words and phrases defined, which is point 22. So 939.22, it defines human being when used in the homicide sections means ones who has been born alive. So again, I'm not here to debate any of that other than to note I can understand why all of those things would be listed under life. But for purposes of the lesser included statutes and really just looking at how Wisconsin law defines human life, there's a reason why some include homicide and some do not. That's really all I want to put or say about that. And we know from looking at the case law and the statute itself that, and I referenced this earlier, for example, mutilating a corpse would not be a lesser included. It's not any form of homicide. So for this court to say that just because assisted suicide falls under subchapter 1 and therefore is a type of homicide is not supported by the statute itself and the context and the clues and the headings that we have. But I looked further than that. And it's really important that we look at the definitions under Wisconsin law for both suicide and homicide. So suicide is the voluntary and intentional taking of one's own life, whereas a homicide is where another person intentionally causes the death of another human being. Assisted means, and again, really quoting here from the jury instructions, that a defendant intentionally, in some method or manner, helps or aids another to commit suicide. And when you look at homicide, it's cause. So there's a very big difference in the statutes themselves and how one violates those statutes. Assisting is not causing from a legal perspective. And so not only is suicide not a homicide, because suicide is the voluntary and intentional taking of one's own life, and a homicide is the causing of the death of another human being, assisted suicide cannot be a homicide for purposes of the lesser included statute because it concerns helping or aiding and not causing. But even if this court were to consider assisted suicide as a type of criminal suicide, my finding would be no different, that it's not appropriate to instruct the jury in this case, primarily because there's a denial of intentional behavior related to Lynn Hernan's death by Ms. Kurczewski. Now, of course, I don't just look at isolated statements. I need to look at the evidence as a whole, and would there be a reasonable basis? And I know that there is case law to suggest or to say that if a court is in doubt, you should give the lesser included. But the standard also isn't any evidence. It's whether there's a reasonable basis to acquit on the more serious charge and convict on the lesser charge. And there is just no support on the record before me that, and I'm really focusing on the third element of assisted suicide, that Ms. Kurczewski provided assistance with the intent that Lynn Hernan take her own life. On the contrary, there's evidence, and I think a reasonable view of the evidence is that she did not believe the tetrahydrozoline would kill Ms. Hernan. So that is my ruling as it relates to the defense request for the lesser included. I will deny the request to include that, and I will not be instructing the jury on assisted suicide as a lesser included offense. I do not believe, for the reasons that I've stated, that it is supported by the statute or the law in other respects, understanding that there is no Wisconsin case that has directly answered question number 1. I want to add that when I considered this a little bit more on how I looked at the reasonable, basis to convict on assisted suicide, I acknowledge that with element number 1, there certainly could be a reasonable view of the evidence as it relates to that element that Lynn Hernan committed suicide. I think even when looking at element number 2, when looking at what assist means, and that's to, in some method or manner, help or aid the deceased to commit suicide, I think there could be some. It's really that third element that I do not believe even a reasonable view of the evidence supports. Including what I said earlier about Ms. Kurczewski claiming to not know it would kill someone, her statements such as, had I known, I would not have left, her intent to appease the victim and the evidence around that is, there's not a reasonable view that appeasement was for the intent that Lynn Hernan kill herself. The detective's statements and questioning whether it be their belief or just the way they did the questions and pushing, my word, Ms. Kurczewski, kind of confronting her with their belief about assisted suicide is not enough. Her exculpatory, and I further dug, and there's cases to support me doing this, so first of all, her exculpatory type statements cannot be the basis to support a conviction on assisted suicide. By that, I mean exculpatory in the sense of her denying either intentional acts and just knowing or claiming that she was suicidal would not be enough. I have to look at the other evidence and that's in the record. And I'm aware that even if there's some contradictory, positions, again, going back to that standard, as long as there's a reasonable view and supports a conviction on the lesser, but I'll acknowledge that I think under that particular analysis, it's a much closer call, but for the reasons that I've just stated, I still cannot find that there's a reasonable basis for that. Again, somewhat of an academic exercise because of the way that I answered question number 1, but I also thought it important to put that on the record as well. With that, Attorney Kukler, is there a request from the defense that the jury be instructed on any other lesser included offenses?
No.
All right, then I will not go through any analysis then as it relates to that. I realize we do need to provide then the parties with a final version for approval and then the verdicts as well. Where are you at with that, madam? So it would just be the first version of 1018 that we had. No bridging, no alternate. And then when we get to the very last part of my pages got a little bit out of order. Here we go. As to count 1, it would be the standard verdict questions that we have with the not guilty first, followed by the guilty. And then I believe we have the verdicts already approved, right, as to counts 2 and 3, notwithstanding the objection by defense on some of the language. Is that right?
Yes.
Yes, that's right.
Any other instructions that you've perhaps thought about over the lunch hour that you want me to include, or any other modifications or edits?
Not from the state, thank you.
No, thank you.
All right, as soon as Madam Clerk has that, I'll have it emailed, or we can just simply put it up on the screen and just kind of scroll through it just to see and get final approval.
Okay.
Yep.
I'm not surprised you didn't put it in, but I don't know. To see the poll.
Do you want to put it up for all of us? I put it on the preview.
45% thinks guilty across the
It's
board.
easier to read those. Why don't you just go back up to the, so she can see, go back up to the, we all can see.
36% think it's guilty financial crimes only, and 18% not guilty.
Very beginning.
Oh.
All right, just so you can see I don't put the case number on for the jury. Okay. Any objection to that from the state?
No.
From the defense?
No.
All right, page 1 we've already talked about. So here is the beginning of the first count of the information. It's the standard 1018, notwithstanding the request from the defense, though. Do you approve as to the language?
Yes.
No, Johnson.
Or this page looks fine.
Here's page 3.
That page looks fine too.
Okay. Hold on, do you see what she did?
Yes.
So that it says theft of movable property in the heading to be consistent with the verdict forms?
Right.
Thank you.
Any objection from the state?
No.
From the defense?
No.
Okay. And then here's, whoops, go back up a little, count 3. Again, the heading theft was changed to theft of movable property to be consistent with the verdict forms.
Aye, aye, aye.
Let me know when we can scroll down. Yes, that's the original language, other than it says theft of movable property and not just theft. Oh, what else did we change?
There was like changing the one thing to in 2010, so I'll just go and make sure that.
Oh, that's great. Okay.
Yep. Did you get the highlight out of there?
I did.
Okay.
Oh, could I? There's a funny parentheses after the must under reasonable hypothesis.
I think that's my cursor.
Yes.
It's a cursor.
Oh, okay. Got it. All right.
Oh my good days. Let's get through it. Come on. Let's call it a night. Come on.
Yeah, that's right.
I'm tired now. Remember Matt Moore tomorrow.
Well, nope, we all approved this earlier. Nothing changed with that. So you keep going. Keep going.
I need to add the 2010 thing back in.
But that's the other acts. If you want to.
Yeah, that's just. I think that's the only main difference here.
That's the cautionary. You're not to it yet. You got one more to go.
There we go.
Yep. So it should say that in 2010. Did you need my notes on that, or do you think you're good?
More Matt Moore. So
I have it in another document.
Got it.
Actually, Teresa and Clerk, if you could put the word in before 2010.
Yeah, no comma, and then
No
just
comma.
No comma.
no comma.
And no comma after 2010 either.
2010.
Hmm. Why are you telling Matt Moore?
And
Matt
attempted.
Moore.
Yep, you got that in. Attempted. Both.
Am I okay to scroll?
Yep.
Yes.
So when you get to, hold on.
We didn't mess with that.
We did not. We did not. Did you have the changes to a defendant elects not to testify, or is that in a different spot?
That's coming up, but I need to make it the same as the other one and just add the cautionary statement
Okay.
heading, which isn't in this one. Going back to what
What's that stated?
Okay.
Can you slow down for 1 minute,
Sorry.
please? Yeah, do we say may not above, but now we say you may consider this evidence, or we say we may not consider it above?
What are you talking about?
You may, right there, you may not consider this evidence.
You may consider this only for the purposes I have described, giving it the weight you determine it deserves. It is not to be used to conclude that the defendant is a bad person and for that reason is guilty of the offense, should be offenses, by the way, plural, charged. That's the standard language, other than adding the description.
Sorry, John. I'm too tired now. Come on, I'm falling asleep here. Like, come on, Judge. Let's just get it over done with.
Oh, we're in defendant elects. Okay, you can. There was no changes made to the one you're on. So go down to defendant elects to testify, and then take out.
Can we say, instead of the defendant's decision in that second paragraph, can we say Ms. Kurczewski's decision?
These are standard instructions, and so they need to be consistent. Since we're not doing instructions until Monday, are you requesting that I change all references from the defendant to Jessy Kurczewski?
I was just asking for it in that particular spot.
Can you go back up, Teresa? I know you're trying to do what you're doing, but stay where we're at.
Just in the second paragraph there.
You want instead of, okay, any objection to that?
No.
Okay, so Teresa down there, yep. How would you like it to read?
Ms. Kurczewski's decision. Thank you.
Okay, and then it says cautionary. All right, that should be good. Exhibits should be good. Teresa, let's see. Number jury, just make sure you have that one out. Coming up in a little bit.
I'm fading here. I am fading very, very quickly.
I think you did already.
Oh.
None of this changed. Mm-hmm.
People stop sleeping, nodding off.
And then can you do a page break where it says verdicts? Because I read that after.
There won't be 5 forms. That's incorrect.
It'll be 6.
6
Like
forms.
I have to fix count 1 to.
I need to fix this mic then. Monday now.
Switch that 5 to 6.
Oh, excuse me. So I've got to go, Kate. It's more about falling asleep. That's all.
All right, I'll have Teresa finalize this, email to the parties. I think generally where
I would be, John.
Where we need to be. I won't have her. You can take that down. Finish doing that, but it'll get emailed to the parties. You'll have that opportunity to review it. Feel free to include me on the email because I have access to it. And if there are any things that come up over the weekend, I could go in and change it upon agreement of the parties. See, we'll make sure with the email will be all the separate verdict forms. So that very quickly Monday morning we can just do a final. We've reviewed it and approve of it. Okay. Don't think I've overlooked anything, but anything else from the state?
Oh, thank you, Your Honor.
Anything else from the defense?
No, thank you.
All right. Thank you, everyone. That concludes the hearing. Good luck as you prepare your closing arguments. I look forward to watching them, and I will see you Monday morning at 8:30.
Thanks, Judge. Have a good weekend.
Thank you. You too. We are in recess.
Happy days. So I need to go and look at my audio. My audio has not changed. Mecky, have a look at some of the members only earlier on. Jesus, we were having fun. Lovely to see you, Mecky, as we're leaving. How they done so early? Over the tea pond. Yeah, no, do you know what? I'm going to lie down on the sofa, drift off, probably. Now I'll be on the sofa, probably won't be able to sleep at all. But yeah, I'm getting old. I'm getting old, guys. I'm 41. Do you know what I mean? So yeah, we will be here tomorrow. First of all, tomorrow at 9 o'clock. No. Tomorrow at 10 o'clock Eastern, 11 o'clock Central, 4 o'clock UK time, 5 o'clock European time. Matt Moore, more Wednesdays or more Saturdays. We've got that going on. It's going to be a short stream tomorrow. It'll be a shorter stream than normal tomorrow. There's only about an hour and a half testimony tomorrow, and obviously usual spiel and stuff. So probably about a 3-hour stream tomorrow, compared to like the 4, 5, 6, 7 hours we normally do. So keep it short tomorrow. Laugh at my heart. Old. Wow, you don't look for it. Thank you very much, Carol. Thank you. I think after Jonathan, I'm the youngest here. No, 16. 16. Mecky, yeah, you love her all. I think I'm pretty. No, I'm not saying I'm young. Sorry, I'm saying that wrong. Most people here are in the older generation, so which I love. And yeah, I'm here, 41. Most people don't think I look 41. Most people think I look younger, but I'm definitely 41. So 42 next year, April. Jesus. But there we are. What can I do? What can I do? But I'm glad Mecky Taker came in. God gave me a smile to see Mecky come in. You were a baby. I don't know about that. Don't know about that. The baby is Jonathan. Jonathan, what's Jonathan? 30, I think Jonathan is. Jonathan's a baby. Well, actually, Luna's the baby. She's 27, I think. But then she's the baby of the family, with Jonathan being. And I think I'm probably the youngest then. After that, after Jonathan, I'm the youngest then. In terms of males, that is. Mexi Taxi. Oh, Mex. I call you. Right, okay, hang on. I call you Mecky Techie, but it's supposed to be Mexi Taxi. Jonathan is my daughter's age. There we are. Well, Jonathan's married since he was 19. And he's married to Sherry whenever Sherry pops in. So, how, yeah, which one is Jonathan right? Is it Mexi Taxi? Or am I doing it wrong? Because I always call you Mecky Techie. Oopsies, if I've done that wrong. Your stepdaughter's your age too, Jesus. Carl's big 50 next year. He's still quite young compared, we got a few oldies, golden oldies here. We've got Dave Umberger. I think Dave's the oldest, 69. He's 69, but he's been 69 for the last 5 years, I think, so. Mexi Taxi. Frankie, Nora. What are you telling me, Mexi Taxi? I can't say that. Is it Mexi Taxi sexy? Sexy taxi. Sexy Mexi. Mexi Taxi. Sexy taxi. Sexy Boise Mexi Sexy. Jesus, you could have confused the hell out of me. Mexi Taxi. Well, I apologise, but I'll call it Mexi Techie. I don't think I can change that now. Mexi Taxi. Mexi Techie. Mexi Taxi. Mexi Taxi. Mexi Taxi. Mexican Taxi was the inspiration guaranteed. Mexi. Exactly. I explained it the other day. Did you? Not to me. No way. I always listen to Mexi Taxi. Mexi Taxi. She's sexy. Mexi Taxi. Very sexy. Do, 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 do. Mexi in Italian accent, lol. In this chat, well, fuck. Well, do you think I listen? Mexi Taxi. Mexi Taxi. She's a very sexy voice. Her voice is very sexy. Mexi Taxi. I'll try and remember. I probably won't remember. Sorry. I'll probably continue calling you Mexi Techie. But just look at this. You're unique, yeah? You're unique. Do you know what I mean? But anyway, right, I need to go. We've got Matthew Moore on Monday, tomorrow. And then on Monday, we're back. We've got court at 8:30 Central, 9:30. I was probably start at 8:15 Central, 9:15 Eastern, 2:15 UK time, 3:15. Is it? 2:15. It's 8, 9, 10, 11, 12, 1, 2. 2:15 UK, 3 European. Yes, you do. Unique. Go to bed, man. I am. No, I'm not disillusional. It's fine. I am tired though. I'll be honest with you. It's not 9 o'clock yet, so I'm gonna just look at some stuff on my computer and then just leave it like that. Zachariah. Gravy and cookies. Come, gravy and cookies. Ja. Zachariah. Yes. White. Right, my voice is starting to go as well. So, with that, everybody, I love you all equally. Some more than others. Joking. Hopefully, the mic was doing okay today. Give credit to myself. And thank you, John, for helping out. But it is too echoey for me. I need to make sure it's like the room's too empty. So I need to do something next week now. Roast beef taco, white beef, gravy beaver. Take care for gravy beater. Oh, on that note, we better go before I get another strike. Right, everyone, thank you, love you, and as always, we end off with a free Zachariah Anderson. Take care, guys. Hopefully see most of you tomorrow. If not, see you Monday.